Things are working, and delighted that you could participate from your location. We have certainly a quorum.
I know, be careful.
A quorum of our members here. For the record, let's see, starting down on my left, of course, Judge Grimm is with us by speakerphone. There we go. I'm sorry. Mr. Ipak with us in the room. Mr. Koudalakis is with us. Good morning. Ms. Bernard. Good morning. And Dr. Christian.
Hello, everyone.
And Delilah is here, and of course, ex officio, I guess, Deputy Secretary.
Yes. Good morning, Mr. Chairman.
Good morning. Good morning. Let me just make a few observations before we get started with the really excellent panel of presenters that our staff has lined up for us this morning. One matter, the material has been pouring in one way or another, and we thank some of you who are present and others who are not for those materials, and we'll get to the really superb work of the Joint State Government Commission towards the end of our morning's presentation, but we do have now a super compilation of the laws of other states for our deliberations, as had been requested. I received at least one communication that suggested that there was some concern on some people's parts, whether because of press accounts, and I will say that I learned long ago that you can't control what the press prints, and you kind of can't run your life on that basis. But some concern has been expressed that it was at least perceived that the focus of our deliberations with regard to abuse were either primarily or exclusively sexual abuse of children. And that is not my understanding of the resolution, not so far as I can understand. Abuse as it's defined, all aspects of abuse as it's defined in the law, is part of our charge under the resolution which created us, and that's certainly the basis on which we're proceeding. And if I needed any reminder, the fact that a little girl under the age of 2 just died in Bucks County short time ago. We will be probably be attending the autopsy on Saturday. The physical abuse of children is sadly very, very much with us, and is of great concern to this task force. Let me thank recognize, I suppose, one of the packets of material which we received, I believe from Ms. Palm, is excerpts, I suppose, from some of the testimony that was presented at hearings held by Senator Ward, I guess, Vicki, last year?
In August and October.
Okay, of 2011. And I must say that covered an awful lot of the territory that I think we're going to be wanting to cover, and certainly doesn't substitute, maybe we can have some of the same presenters or certainly cover some of the same area, but wonderful groundwork, and I'm sure a part of the reason for the Senator's sponsorship of this resolution.
And it can be viewed on the Senator Ward's website under Aging and Youth. Both those hearings have testimony for the August hearing. In October, we have a video.
Great, great. So that's a resource both for us and anyone else who's interested and doesn't already know about that. The other, fortunately, Dr. Berger wasn't able to be here today. She provided some excellent materials, reports from several, not all, I believe, of the citizen review panels, which are another entity concerned with this subject. And I found some of those materials fascinating reading, and I think that as we get into later on today, sort of planning our first couple of hearings, I think we're going to want to hear from some of those folks on the record, as it were, in our proceedings. But that was excellent material that I think also focuses on the why we're here. So unless anyone has any preliminary matters to take up, our purpose this morning was to sort of further supplement, let's say, my education. I'll assume the rest of you all know about all aspects of the child abuse system, but I think I know about some ends of it, but very little about others. And our staff has assembled a first-rate group of people, each beyond experts, people who have deep experience in their particular aspect of the process of dealing with child abuse, to kind of establish a baseline for us and get us up to speed. And our first speaker is Ms. Lori O'Connor. She is from Montgomery County, and I don't have a title here, but I'm guessing you're the person in charge of the Office of Children and Families of that county. So, Ms. O'Connor, the floor is yours. Come on up and have a seat there in front of the computer, and I'm sure the AV man would wish me to tell you, or wherever it's convenient for you, but make sure you push the, I should know, every speaker has a computer and presentations. I'm
Lori,
kind
would
of.
you like somebody to come up and do that for you?
I'm kind of old school. The one trial I prosecuted in my new life as a prosecutor, I tried to struggle to get pictures so that I could just hold them up in front of the jury. And finally, a young assistant DA was assigned herself to me so she could push the buttons on the computer. So I don't think in those terms.
Maybe you bet.
Did you press your button?
I believe I'm on.
There you go.
Thank you so much. First, I'd like to thank you ever so much for providing me with this opportunity to come and address the task force today. I believe that you have a very challenging and a very, very important job to do, and your work will really benefit our children and families throughout the Commonwealth. I'd like to start today by providing you with just a little bit of background about Montgomery County, which is the county that I represent today. Montgomery is the third largest county across the Commonwealth. We continue to experience growth, and at this point we have about 800,000 residents, 183,000 of which are children. Our county is very diverse. We have urban communities, we have suburban communities, and in the far northwest region of the county, we really still have some very rural areas. So the diversity of the county, I think, is exceptional. The second largest foreign-born population in the region also lives within Montgomery County. We have folks who are continually moving into the county who need to have additional supports and services to help them acclimate to their communities. With this very large county, child welfare services are provided by an agency that falls under the jurisdiction of the commissioners. In our county, we call the office children and youth. You'll hear other counties across the state refer to children and youth services, children, youth, and families, but just for purposes of specification, if I happen to mention OCY in my presentation, you'll have an understanding of what I'm talking about. Children and Youth in Monco has 148 staff. 80 of those staff are our caseworkers, who are those individuals who are on the front line providing services to our children and families on any given day. They're supported by family support workers, by supervisors, by specialists who work with them in regard to making sure that our families are connected with important human services across the county, with community services, and with the courts. I believe it's important for me as well to provide a general perspective for you as I begin my presentation today. The public's responsibility for child protection is based on some of the following tenets. I did pull this information from the National Child Welfare Information Gateway, which has a wealth of information and research with regard to child welfare, child abuse, investigations, as well as many statistics. The perspective of child welfare is really grounded within the community, and from the child welfare system's perspective of services, we really want to make sure that we're focused on the responsibility of our communities and the public interest in protecting children, in making sure that they have opportunity to grow within a safe and stable family, with support from those individuals in human services and in other systems that help us on a day-to-day basis to keep them safe. No single agency or individual alone can tackle the responsibility that we have for keeping our kids safe. From a single systems perspective, whether it be child welfare or law enforcement or the medical profession, none of us has necessary knowledge, skills, resources to be able to provide all the services that our children and families need. I want you all to really bear in mind as I talk with you today that most parents really don't intend to harm their children. The important thing to keep in the forefront in making sure that we were focusing on is to make sure that families are the focus of all of our thoughts. Our intervention has to be sensitive to culture, values, religion, and other differences shared across our children and our families. Abuse and neglect can be the result of a combination of psychological, social, situational, societal factors. The many professionals who respond to child abuse recognize that maltreating adults have the capacity to change their behavior, and it's our job to make sure that we give them every optimal chance to do so. Growing up in a family is optimal for children. Children don't belong in the foster care system. They belong with their families. If that family cannot be their parents, it should be family members, whether it be grandparents, aunts, or uncles. However, keeping all that in mind, when parents can't or will not meet their children's needs, removal from the home might be necessary. All efforts to develop a permanent plan for a child should be made as quickly as possible. A permanency plan is to reunify the family whenever that's appropriate, and when reunification is not possible, a permanent family is sought for a child through adoption or permanent legal custodianship. In Pennsylvania, our child welfare system is state mandated and supervised, but it's operated by our counties. State and federal statutes and regulations dictate specific required actions that have to be taken in the investigation and assessment of a child welfare referral. Our primary state mandates are outlined in the Child Protective Services Law and in the Juvenile Act. The Department of Public Welfare, specifically the Office of Children, Youth, and Families, promulgate regulations that direct the way in which mandates are implemented across the state and what actions counties have to take to assure compliance with those. However, our counties do have a level of flexibility with regard to how we provide our programs and our services. We implement policies and practices that meet our local needs and conform with all of the above. No two counties undertake investigations and assessments in exactly the same way. Demographics, resources, policies, and practices across the state or county specific. Our system in Pennsylvania allows for flexibility by counties so local needs can be met in the most appropriate manner. Human service systems organizations also impact that policy and practice, and each of our counties are organized in a different way. Just as local response varies from Montgomery County to Franklin County to Lackawanna County, no two investigations or assessments are exactly alike. The process is frequently conducted in concert with other professionals. Law enforcement investigates criminal acts. Medical professionals evaluate and treat injuries to children. Human services provide treatment as well as supports that families are in need of to keep their kids safe. Community services support families before, during, and after intervention. My focus today in the investigative and assessment process really is going to be in helping you to understand that the process itself is not linear. It's subject to changes dependent on unique facts and circumstances, and it cannot conform to a particular schedule. That investigation process really is dependent upon information obtained by a children and youth agency, information obtained by other professionals involved in an investigation or provision of services to a child and a family, safety and risk factors that have impact on children, and changing circumstances of a family. So I'd like to then start you at the beginning. The child welfare investigation process begins when a referral is received from the community. In Montgomery County, a screening unit of 6 caseworkers and a supervisor provide response to all new contacts with the agency. Referrals are taken 24/7, 365 days a year. They're received from Childline, our state child abuse hotline, mandated reporters, community members and family, as well as anonymous reports. That method of receipt can vary. It can be through phone call, it can be through someone walking in our front door, it can be via email through our county's webmail site, or it can be via letter. Most referrals are received from schools, social services, and law enforcement in Montgomery County, but mandated reporters encompass many other professions. Those reporters are required to make a report to Childline when they have reason to suspect that a child is being abused. If a call is received by the state child abuse hotline, a referral is then submitted or made to the county agencies that have the responsibility to respond. Our counties can also receive those calls directly. A mandated reporter may contact Montgomery County's Children and Youth Agency for a consultation or advice on whether or not a situation meets that threshold for mandated reporting. When that call is made to us by a mandated reporter, we'll either refer the reporter to Childline or we'll make that call ourselves. I really hope that with this overview, I'm able to provide you with an understanding of how a county Children and Youth Agency responds to reports and how an investigation unfolds. Some aspects of response are consistent across counties, as I mentioned, because they're outlined in statute and regulation. Other aspects are county-specific. So my presentation as I move forward is based upon Montgomery County's response in those areas where counties have flexibility. I mentioned that screening unit and the screening caseworkers that take all the incoming calls from the community. The screening function is really vital to the safety of our children. The responses to those incoming referrals needs to be immediate and it needs to be thorough. So the screening caseworker obtains information from the caller. Referrals are subject to screening and additional information is gathered by a screening caseworker. Collateral contacts are made to collect additional information from persons or organizations who can be reasonably expected to possess or who are known to possess information about the child and or family to assist in evaluating the situation. Those collateral contacts can be made to family members, neighbors, police, schools, medical personnel, or social services. The screening caseworker then has to make a decision about what the response should be and if any kind of a response from the Children and Youth Agency is appropriate. A supervisory review of the referral is conducted. Additional information is obtained if the caseworker is directed to do so. And then the referral is evaluated in terms of statutory parameters set forth by the Child Protective Services Law and by the Juvenile Act. A final determination about the need for intervention is then made by the screening unit supervisor. Most referrals that come into a children and youth agency are from people who are in need of information about services that really don't fall under the jurisdiction of the child welfare system. A referral can be screened out at screening and not receive a response at all. Under circumstances in which a report does not fall under jurisdiction of child welfare, the response could include the following. Information may be provided to the caller if it's available. The family might be contacted to discuss their needs and information or referral provided to them over the phone. Assistance might be provided to a family by making contact with other human services, the courts, or law enforcement so they have an opportunity to follow up. In Monco, if assistance might be available from another categorical human services system, the call is transferred with the request that assistance be provided. Examples of these kinds of information referral types of responses might include someone who calls for information on how to obtain parent-child counseling, someone who requires child care and doesn't know who to call to find a safe and reputable agency, someone who calls requiring medical care for a child and does not know how to apply for CHIP or might not know where to locate free or low-cost services in their community. We receive many calls about court. People call for information with regard to how to file a petition in family court. They might call not knowing who to connect with in order to file a protection from abuse order, or they might call because they have needs for services. A family might be facing eviction. They might be in need of shelter, food, clothing, or other services that are available in the community. Sometimes those initial calls that come into the agency involve what at the county level we call a law enforcement only or law enforcement referral. If an individual within in the community has a concern that a child might be abused, they have a responsibility to contact Childline. But some of those calls do not fall under the definition of child abuse as it's defined in the Child Protective Services law. In those cases, Childline contacts the county Children and Youth Agency, and that county has the responsibility for then contacting and making sure that that referral is received by our local police department. Student abuse reports also fall under situations in which the County Child Welfare Agency does not have the primary responsibility for responding. If a suspected student abuse report is made, or a report where an employee in a school district is suspected of abusing the child, the police department and the district attorney are the first responders. Upon initial review of that referral and investigation, law enforcement or the prosecutors will contact the Child Welfare Agency so an investigation can move forward in a collaborative manner. A referral requiring this information and referral type of a service does not receive any response beyond this initial screening function. When a call is made to a child welfare agency, and it's not screened out, so to speak, through information, provision of information or referral services, it does not necessarily receive a formal response. In Montgomery County, a referral can be screened in, and then there are two possible tracks that intervention can take. The first of those tracks involves the provision of brief services. When more information on a referral or connection to another system is required to address a referral, a brief service could be provided by a screening caseworker. An in-home person visit is made by that screening caseworker to make connections with the family so they can secure services within the community. The services that are generally needed upon that initial face-to-face visit with the family in their home are crisis intervention. It can be a service that is available in the community that a family can be connected with, such as our Nurse Family Partnership, our Family Center programs that really have a preventive focus. And that preventive focus is intended to provide a response to divert the family from the requirement and need to secure child welfare services. That brief service response allows us to, as early as possible, help a family make connections with services such as women, infants, children, that provides nutrition information as well as evaluation for families who have infant children, for early intervention referrals, for referrals to CareerLink or training and employment services, for child care services, or for behavioral health or developmental disabilities. It also helps us to provide some necessary connection to community services, such as families who would receive support through food cupboards or emergency shelters. If that brief service response is not perceived to be enough or to meet the need that the caller outlines when a call is made to us, the second type of response is made through that screening department. The second type of response means that a referral is screened in for services and that it's going to be set up for assessment or an investigation. The response in this case is either through a Child Protective Service response or a General Protective Service response. And if a referral has an immediate need that is addressed, it doesn't wait for formal assignment. That screening caseworker goes out and makes the initial face-to-face contact. When a referral is screened in, information obtained during the screening process is reviewed by that screening supervisor. The supervisor provides the caseworker with directions. What do they tell them to do? Make additional contacts, obtain more information so that the response is the most appropriate possible. They may direct the caseworker to respond immediately to determine if there's need to take child protective action, or they may respond with direction to set the case up for an investigation or assessment by an intake caseworker. A record check is completed within the county's system to determine if there have been prior contacts with the Children and Youth Agency. In Montgomery County, we maintain an electronic record, meaning everything all the information that is gathered with regard to a particular case is entered into a system electronically. It can then be accessed on-site or it can be accessed off-site. A response time is assigned to the case. That response time is really very, very important. It's based upon safety and risk factors to the child, and it's identified through those various screening activities that I described for you a few moments ago. That response time can indicate that immediate contact with the child and family needs to be made. It can dictate that a child be seen within 24 hours. If the referral that's made to us involves a Child Protective Service response, the child must be seen within 24 hours, but that child can be seen immediately. If the case comes into us and it does not fall within the parameters of that child protection system, it's assigned a GPS or a General Protective Services response, and that dictates that the response needs to be made within 7 days. Can you speed it up?
I'm sorry to interrupt. One of our members had train difficulties, I believe, and I was just welcoming her. The record will reflect that Carol Hobbs Machato has joined us, but go right ahead.
Thank you. When that referral requires a CPS or a GPS response, it's assigned to an intake unit for investigation. Now, this means that case is going to be transferred from the screening unit to an investigative or an intake unit within the agency. And any case that requires that this level of response is prepared for an investigation by a screening caseworker and then is transferred to an investigative unit for assignment. A couple important things to note with regard to this transfer process. All that screening activity, contacts are documented, and in Montco, the case is assigned to an intake unit in one of 3 locations. We have a central office, and we have 2 satellite offices in the eastern and western portion of the county. The screening unit contacts the intake investigative unit. They provide a summary of the case, actions to be taken prior to transfer, and make sure that upon transfer, any immediate action that needs to be taken as the investigation unfolds is thoroughly communicated. That contact can take place by phone, or it can take place in person if the investigation is moving from the screening unit to an investigative unit within the agency. Upon assignment to an intake unit, A supervisor reviews all of the information that has been gathered to date and provides direction to the assigned investigative worker so that the investigation can move forward. That supervisory review of an investigation takes place on an ongoing basis, but it cannot exceed a 10-day period. Let's talk a little bit about a CPS investigation. 750 investigations were conducted in Montgomery County in 2011. These investigations have a 30-day time frame, which under necessary circumstances could be extended to 60 days. The purposes of that Child Protective Service investigation are outlined in the Child Protective Services law. And so the Children and Youth Agency has a responsibility to make determinations with regard to several things. One, is the child a victim of abuse? Two, who is the abuser? Three, what type of a status are we going to assign to the investigation at its conclusion? I want to step back and talk a little bit about each of those initial 3 steps. About 74% of all the investigations of child abuse that are conducted in Montgomery County involve some type of a physical injury to children. That can be bruises, welts, lacerations, or it can be something that's much more serious in nature. Skull fractures, hematomas, strangulation, drowning. 20% of the reports involve some type of sexual behavior committed upon a child. That can range from fondling or touching a child inappropriately to rape and incest. Mental abuse is a form of child abuse that we don't frequently talk about, and I think it is likely the most elusive form of abuse for most professionals. Mental abuse has to be documented by a physician, pediatrician, or a psychologist or psychiatrist in Pennsylvania to determine if a child suffers from a serious mental injury. Neglect can rise to the level of child abuse if it becomes serious, if the neglect is prolonged or it's repeated and the child suffers an illness or an injury. A child can also be placed at imminent risk of a physical injury or sexual abuse. This type of report is not common because it's very difficult to determine whether or not the action of another individual is something that results in a child not being injured or abused. A perpetrator or an individual in Pennsylvania in a Child Protective Services investigation who is classified as a perpetrator is characterized as the following: a parent of a child, a paramour of a child's parent, an individual 14 years of age or older residing in the same home as a child. That's very different from what we consider to be a child abuser and very different from the definition that the criminal justice system would place on a perpetrator of abuse under some circumstances. The child welfare system's response then is limited to those cases in which a perpetrator, as defined under the Child Protective Services law, becomes the focus of an investigation. We talk a lot within the child welfare system, and the public talks a lot about the outcomes of Child Protective Services investigations. An investigation can culminate in one of 4 outcomes. The most confusing for the general public is a determination of unfounded. An unfounded determination does not necessarily mean that a child was not subjected to some kind of inappropriate activity or that a child has not been injured. It just means that there's not enough information to substantiate the investigation based upon the current definition of child abuse in Pennsylvania. An indicated report means that the CPS investigation, medical evidence, or a child's admission can result in providing sufficient evidence to find that the child is abused. A founded report is one in which a criminal prosecution and conviction occurs, or a juvenile judge makes a determination in juvenile court or family court that a child has been abused. Finally, if a situation is pending criminal or juvenile court action, the determination can be stayed for a period of time until that prosecution might occur, or the juvenile court makes a final determination with regard to dependency. Most Child Protective Services reports are received from mandated reporters, schools, police, social service agencies, hospitals, parents, friends, neighbors are the most frequent source of reports. I think it's also important to note that under certain circumstances, child abuse reports require that the Children and Youth Agency make a mandated formal report or provide notice to law enforcement in cases in which allegations involve sexual abuse, serious bodily injury to a child, fatality, or where a perpetrator is not a family or a household member. The Children and Youth Agency makes, we make in Montgomery County, an immediate phone call to our local police department, which is followed up then within a few days through a formal written report to the police as well as to our district attorney. That immediate verbal response to police allows the county agency to move forward in a collaborative partnership with them in conducting an investigation. Child Protective Service actions are defined for you on one page of this PowerPoint, but in the interest of time, I'm going to move beyond that and let you take a look at those yourselves. What I'd like to highlight for just a few minutes is the multidisciplinary team investigation process that we utilize in Montgomery County. That MDT process, as we refer to it, involves a collaborative response to investigations when the child abuse referral involves sexual abuse, a serious bodily injury, a fatality, non-fatality, or near-fatality situation, student abuse, or a law enforcement-only report, or any other kind of situation where one of our MDT members believes that the team response will be of benefit to the investigation. We have children who are siblings of abuse victims, witness to crimes, who are also seen, and the MDT process unfolds throughout the course of the investigation. In Montgomery County, these MDT or team investigations occur at our Child Advocacy Center, Mission Kids. Mission Kids services provide for a forensic interview of a child, a medical evaluation of a child, an exam, only if needed, but that's available as well, mental health services if needed for a child, and the most critical part of this process is the team investigative planning and response activities that's coordinated at the Child Advocacy Center. A representative from our district attorney's office, the local police department involved, the Office of Children and Youth, a medical professional, a mental health professional, child advocate, and where appropriate, the guardian ad litem, all work together to observe a child interview, to plan, to move forward in the most appropriate manner in a case, and then to provide some debriefing and coordination of investigative activities and determinations with regard to services that are required by a family. Many of our reports, or many of the cases that receive that MDT response through our Child Advocacy Center are those law enforcement only types of reports that I mentioned to you earlier. Even if the Office of Children and Youth is not conducting a formal child abuse investigation, we sit at the table, we participate in that planning process, and the case then can move forward in a coordinated manner. We find not only is this in the best interest of our children, whom we don't want to traumatize further than they've already been by a situation involving abuse, but it results in better services for the family and an increased prosecution rate. Not all referrals that are received by a Children and Youth Agency involve child abuse. In fact, the vast majority receive a general protective services assessment. I'm going to differentiate for our purposes today between a child abuse investigation and a general protective services assessment, because an important message for all of you to take away from the meeting today is the fact that some responses require child protective service action, but all Children and Youth Agency responses involve an assessment of the general safety and well-being for a child. In comparison to those 750 child abuse reports that were investigated in Montco last year, 1,286 General Protective Services assessments were completed. They're not exclusive, as I mentioned to you. An intake caseworker completes both types of service responses. The purposes of that GPS assessment are also outlined in the Child Protective Services Law, and the CPSL defines for us that those services are services that are needed to prevent potential harm to a child when the child is without proper parental care and control, subsistence, education as required by law, or other care and control necessary for physical, mental, or emotional health or morals. GPS assessment can be provided when a child is placed for adoption in violation of law, when a child is abandoned by a parent, a guardian, or caretaker, when a child is of compulsory school age and is truant from school, when a child who under the age of 10 commits a delinquent act, or when an adolescent is ungovernable. The dependency assessment requires coordination with other human services as well. Just like that CPS investigation requires the input from law enforcement, medical professionals, social services, as we move to the assessment of are a child's needs being met, other human services systems need to be involved. Behavioral health, early intervention, developmental disabilities, juvenile justice, housing, our child care system, our training employment systems are all vital to that information gathering process so the most appropriate response can be provided to the family and we can keep our kids safe. Most frequently, General Protective Services referrals are made to the counties for the following reasons. First and foremost, children are not being provided with life essentials of food, clothing, shelter, housing, adequate supervision, or medical care. Referrals are often made when parents have drug or alcohol dependency that's interfering with their ability to keep their kids safe. When a child is subjected to some type of inappropriate discipline that does not rise to the definition of physical abuse under our law. When sexual abuse is committed upon a child by someone who is not a parent, a household member, or who is not in a caretaking capacity. Referrals are also made on a frequent basis when people just don't have a safe place to live or the home is inadequate to address the needs of the kids. There may be insect infestation, that the physical environment of the home may not be safe for a child. And frequently people contact the Children and Youth Agency and make referrals when children are not receiving appropriate medical care or mental health services. In contrast to the investigative outcome of unfounded, indicated, founded in a Child Protective Services report, a GPS assessment status is documented as substantiated or unsubstantiated. As we move through this assessment process, two really important factors to bear in mind are going to be discussed. I'm going to feel the need to mention them. Any kind of intervention by a county child welfare agency focuses on the safety of the child and any potential future risks that a child may be exposed to within their living situation. That safety and risk are constant issues in an investigation, whether it involves child abuse or General Protective Services. And safety and risk are evaluated at each contact that a caseworker has with a child and a family. The safety assessment evaluates issues that impact a child to determine if there is an immediate threat of harm. Immediate threat means a child is being abused now, at this moment, or a parent might be threatening to abuse or harm a child at this moment, or if there's a history of prior harm to the child by a parent or a caretaker. That assessment also has a sister component, so to speak, a risk assessment. And that risk assessment evaluates future threats of harm to a child by identifying persons who are in need of services and factors that have to be addressed to reduce risk levels. We can mitigate risks in many situations by effectuating a safety plan for a child, meaning people who are part of a family's network of supports, be they family or kin, friends, neighbors, community members, are able to step forward and make sure that if there is high risk to a child of being abused, that that child can remain safely in his or her home with appropriate services. Situations in which very successfully that risk can be mitigated involve inappropriate discipline to child, where someone else may move into the home to make sure that physical discipline is not occurring within the household, that a parent who has drug and alcohol dependency issues is always supervised in their contact with the child. If there are immediate threats to a child's safety, though, removal can be indicated. That removal is going to be based on the safety threats and the level of risk that I just described to you. The safety assessment that is completed at every single contact with the child involves evaluation of 6 factors. 1, the type of maltreatment that a child is subjected to the nature of the maltreatment. Okay? Is it serious? How frequently is it occurring? What is it? The child's functioning. Children who have special needs that are much higher risk of abuse than are children who do not have special needs. The functioning of the adult. An adult who has untreated mental health issues, who may have developmental disabilities, is likely not intentionally harming their child, but that level of functioning might be impacting their capacity to do so. General parenting that's practiced within the home, and parents' disciplinary measures. That safety assessment, risk assessment, is part of the ongoing decision-making process that an investigation entails. Caseworker has to make a determination on the status of an investigation within 30 days if it involves child abuse, and by the 60th day if a general protective services assessment is being conducted. Important decision then to make at the conclusion of the investigation is, does the child need protection? Does the Children and Youth Agency have to maintain involvement to keep the child safe and to mitigate those risks? In many situations, the answer to that question is no. There can be safe case closure at the end of that investigation. We may close a case if a perpetrator is not a family or household member and has no continuing contact with the child. For example, a daycare provider who may be abusing children but is not living in the home. Maybe a situation in which a family member who has abused the child has now moved out of a home, or a situation in which a child may move into the home of a relative to assure his or her safety. During the assessment process, kids are seen as often as necessary, but they cannot be seen any less frequently than once every 30 days. If a determination is made that a child doesn't require protection, we might make referral to community services. We might engage family, friends, and services in the community to address the need of the family and ensure that children are safe. Or it may be that no services are necessary and an investigation was made, an allegation that did not uncover any type of abuse or dependency has been completed and the case can be safely closed. If the answer to that question, does the child need protection, is yes, the child and family will be provided with continuing services. That case may be opened. The case most frequently will be opened if a child needs protection and there are safety and risk factors that continue to impact on that child on a day-to-day basis. Often, as I mentioned earlier, those risk and safety issues can be mitigated, and with the safety plan, to which everyone is in agreement, kids are considered to be conditionally safe. They're safe as long as that safety plan remains in effect. Family, kin, again, are really important to us in assessing that safety and maintaining the safety plan. Family also can be provided with continuing services if we have to focus on risk factors and help that parent who has drug and alcohol issues receive treatment, make sure that the family's home becomes a safe place for children to be in. Most of our families accept those services voluntarily. The family then is engaged in identifying individuals and services that will assist them in eliminating factors that endanger the children. Individuals are identified. They can be located by the county agency, and then they're engaged in that planning and the service provision for the children and for their parents. Individuals, family, and the agency meet as often as needed to develop a plan that's focused on meeting kids' needs and keeping them safe. At the same time, an alternative or a concurrent plan is developed just in case plan number 1 fails. The length of time that services might be needed by a family really varies from case to case, and it's based upon the facts and that particular family's circumstances. When a case is opened, a family service plan is developed. The family service plan identifies service objectives, what family members and family and household members need to accomplish in order to achieve the objectives, and the dates for completion of those objectives. As that family service plan is being developed, we're really focusing on engaging the family. At your last meeting, our Deputy Secretary talked with you about family engagement practices, and I'd like to take a few moments here just to highlight those engagement practices for you as well. They're an important aspect of the whole child welfare planning process. Family engagement really is based upon the conceptual foundation that family needs to be treated as a partner. They have to have some degree of input, a huge degree of input, with regard to the services they need, the type of help that they need to receive in order to keep their kids safe. Certain specific engagement practices, I believe Mr. Sanders is going to talk with them a short while from now, are utilized in most counties across Pennsylvania at this point in time. Family finding helps us identify and locate people who might support children and their families. Family group decision-making meetings bring families to the table and give them time to develop their own plans to keep their children safe. Team decision-making meetings in Montgomery County bring family as well as the community to the table to make important decisions about placement of children or how to avoid or divert placement from occurring. Family-to-family meetings in Montgomery County bring our families together with foster families for purposes of keeping birth parents involved if their child needs to temporarily live in foster care or another kind of placement situation until they can safely return home. All the while that engagement is continuing, family progresses towards keeping their children safe, and that risk reduction continues. In very few circumstances, probably less than 15%, a child is in immediate danger in their home and or whatever their immediate surroundings are. When a child is not safe and cannot be made safe through safety planning, temporary removal is necessary. Emergency custody can be taken under those situations. Who can take that emergency custody? A judge can issue a court order to protect a child. A police officer can take custody if he or she believes a child is in imminent danger of injury or illness. A hospital physician or administrator / designee can also take custody of a child for a short period of time if that child is in need. If custody of a child is taken, the County Children and Youth Agency is responsible for finding a place for that child to stay on a temporary basis. That place has to be one that is licensed by the Department of Public Welfare, and it has to be a situation where a family member can step forward and meet requirements for providing a safe and stable caretaking situation for a child until the child can return home. When that child is determined to be unsafe and protective custody is taken, a petition is filed by the next work day with our juvenile court, and a hearing is held within 72 hours. That shelter care hearing, as it's known, is a determination that's made by the court about whether or not sufficient evidence has been presented that a child is at risk in their current living situation and should remain there until further facts can be gathered, presented to the court, and a determination with regard to dependency can be made. The juvenile court retains involvement in situations following that initial detention through an adjudication hearing in which a legal determination regarding dependency is made, and through a dispositional proceeding or services that the court will mandate that the family participate in are planned. And court jurisdiction then continues until a child can safely return home or until a juvenile judge determines that jurisdiction can safely be terminated. Following this, what seems to be lengthy, but really is a short-term investigation and assessment process, a case is closed. That length of service, as I mentioned to you, can be anywhere between 30 and 60 days. If the court becomes involved, the assessment process may take a bit longer as a result of required court hearings. A case is not closed by the County Children and Youth Agency until parental circumstances that could have or have impacted safety and risk of children have been mitigated, and that the children are in a safe and a permanent home. I hope that the overview was not too confusing. A lot of information was packed into a very, very short period of time, but if you had questions, I would love to address them in terms of any specific issues that are of interest to the task force.
There is the strong temptation, of course, to skip to the next subject and, well, what do you think we ought to change? But I think for now we are just getting grounded. Thank you. You have covered an enormous amount of territory, I think very well and very concisely, meaning I think I understood it, and this is the part of the process that I don't know much about. Are there questions from the panel?
I have one.
Good morning.
If there was one thing that you could fix in the system,
There you go.
what would it be to make you be able to feel like you do your job better?
I'd like to mention something I don't believe needs to be fixed, but that I think needs to be highlighted. That would be the team investigative process, the multidisciplinary response to situations in which children are endangered. And the Child Protective Services law mentions and requires a multidisciplinary response when children are endangered. But you can miss it in the statute if you blink. There's such potential for providing an early and effective response if multiple systems are working together in a coordinated manner. And the child welfare system, which focuses on the family, the criminal justice system, which focuses on the commitment of a criminal act and prosecution of offenders, as well as our medical system, our educational system, are all working together from the point at which a child is initially identified as being at risk.
Thank you. And Ms. Romberg, you asked the question that I was tempted to ask. Good for you. I will just promise you that in the course of the hearings, I became converted, as you know, Michelle Henry in my county, my predecessor started a CAC, and we've gotten it, every department locked in, at least from police-initiated matters, and we will have a further presentation about that. I couldn't agree with you more. Doctor?
Hi, Lori. Thank you very much. I have a question about, it's kind of a combination of screening out, what percentage of calls get screened out, and the reasons that you gave for screening cases out were very legitimate reasons, but there are probably other cases that screened out because maybe somebody on the one end of the phone isn't explaining exactly what the problem is accurately, or the person hearing the complaint isn't hearing it exactly correctly. And it's also a question about kind of recidivism. You know, I've seen so many cases over the years where GPS called, GPS, CPS, CPS, disaster. And I want to know if there is a good system for tracking kind of what's happened in the past, especially when you think about expungement laws and things like that, and like, do you have the capacity to know what's come before, how many referrals have been made, who gets screened in and out? That's kind. Do you get the gist of my question?
I do.
Okay.
Pennsylvania does not have a statewide case management system. However, counties are adopting one of a limited number of systems to utilize at this point in time. Those electronic case management systems provide capacity to keep track of referrals that have been made in the past. So, for example, in Montgomery County, the system that we currently use, this system and prior systems have been functioning for over a decade. So I have capacity to know what type of reports were made, when those reports were made, and then to access electronically all the information that was gathered during those prior reports. So I think that helps to answer one of your questions. The state is moving forward at this point with improvements to a technology system. Our counties are working hand in hand with the Office of Children, Youth, and Families to identify the means through which the state is able to access information maintained by the counties. Counties are able to access information that might be maintained across county lines. Many of our families move from one county to another county. That will assist us in making improvements in that regard as we look into the future. I think that the second part of your question was with regard to what information is there and how might, I think what you were getting at is if a number of referrals have been made in the past, how can we avoid multiple referrals kind of culminating in a crisis? And I think that my recommendation with regard to that would be to allow that multidisciplinary team again to move forward in a coordinated manner in all cases. And we're not allowed to do that at the current time. Our current Child Protective Services law mandates those specific types of reports that I outlined for you, where children and youth has to make an immediate report to law enforcement. But it prohibits the county children and youth agency from making reports that don't rise to that level of mandated, meaning the vast majority of reports of suspected physical abuse or physical injuries to children were prohibited from contacting law enforcement with regard to. And there are multiple other situations in which the child welfare system cannot share information with the law enforcement system. Again, I go back to that coordinated team response and that sharing of responsibility.
Further questions? Mr. Kuehler.
Mr. O'Connor, thank you. That was an exceptional presentation and overview. Just to follow up on Dr. Christian's question, does Montgomery County have particular criteria it deploys when screening out or screening in a particular case, in particular for a child abuse investigation and the services that follow? And is that something that the task force could, if you have such criteria, could review as we take on this next phase of what we're doing?
The most appropriate way for me to answer your question is yes, I would be happy to provide you with any information that we have with regard to our practices and our processes in Montgomery County. Certain types of reports that involve a request for information are easily screened out. The very challenge that you just brought up is one that we have chosen to address with the provision of brief services. When we don't feel that there is sufficient information to know if a report should be screened out or a report should be screened in, so to speak, those brief services are provided, which means that a screening caseworker goes to the family home, views the home, speaks to the parent, and sees the child to gather additional information. That reduces the guesswork that's involved in making decisions based on firsthand, sometimes second or third-hand information. So we require that face-to-face contact. We also require an immediate response to the home to see a child whenever a referral involves a child who is under the age of 5. Children are most seriously injured when they're of preschool age. They're not able to report to anyone, and they're not seen by as many individuals, i.e. the schools are not there to keep their eyes on young children. So we mandate that response whenever any child in the home is under 5.
Is it possible in those scenarios where you might do some sort of what I think the term of art is minimal fact inquiry for your screener who takes that initial call for perhaps a child under 5 and makes a determination it does not warrant going out to the home to see the child?
My screening caseworkers are not permitted to make an independent determination that it does not warrant a response. That response is mandatory under all circumstances. But I would like to follow up and just say to you as well, or ask, bear in mind that when that call, that initial referral comes into the Children and Youth Agency, one of the first and most important things that occurs is that initiation of collateral contacts. It's so important that screening process is thorough. When a call comes in, routine calls should be made to the local police to determine if they've had prior contacts with family, if they've been called to the home, have there been domestic disputes, have the police had contact with a family that has not needed to be reported, or at that point in time someone didn't feel rose to the level that it required intervention by child welfare. Reports to schools, if children are of school age, are also absolutely essential. Our children are in school every day, and if anyone knows our kids better than our families, it's their schools. It's their teacher and those individuals who get to know children beginning at age 5 and through age 12, who are able to keep track of them. They know if children are coming to school tired or hungry or dressed inappropriately for the weather. They will notice if there's some kind of a visible injury and will question a child about it. And those mandated reporters, I think, Jason, are conducting what you just referred to as the minimal facts interview, whether it's the police or the school or the pediatrician. Gee, what happened? All right. The requirement for mandated reporters, or for a report to be made, is that someone suspect child abuse. But our child welfare system engages our community, particularly our mandated reporters, on an ongoing basis. That CPSL also requires community education and training. So not a week goes by in Montgomery County where our community relations specialist is not meeting with a group of mandated reporters or soon-to-be mandated reporters who are currently taking college classes. We also participate in the American Academy of Pediatrics trainings, Epic Scan, Scan EMS. I mean, there are a number of scan types of trainings for medical professionals through which a child welfare professional partners with a medical professional to deliver training on identification and reporting of child abuse. Montgomery County has been involved in that for the last 5 years. Dr. Christian can speak, I think, very eloquently to that program and would have many more details than I.
Just one last question. One last question. I saw people's attention and ears perk up when you talked about risk, and at a minimum you see a child once every 30 days. Does that level or frequency of contact with a child change based upon the level of risk that you assign to a case?
What I said was a minimum of 30 days, but as often as necessary. And as a family and their circumstances are initially introduced to us, that face-to-face contact, they used to be much more frequent than once every 30 days. Our regulations require 30 days, but the as needed is on a much more frequent basis.
I have one clarifying question. I'm sorry, just because I want to make sure I understand. That screening call comes in, you gave us examples of lots of things, like I need, I need help, I need some parenting resources, I need to know how to get medical care and CHIP. You don't have a screener go out to all of those homes, just the ones where after you're done with triaging them to the appropriate places, then your screening evaluations come in, correct?
That's
I just
correct.
wanted to make sure.
Thousands of referrals are handled through that information and referral type of a response. The brief services calls were provided to, I think my numbers were 532 families in 2011, 750 child abuse reports, 1,286 GPS referrals. So that just can help you to keep that in perspective. We often can obtain sufficient information from talking with individuals, professionals, who see children on a daily basis, and that goes back to the collateral contacts.
Thanks.
Further questions from the panel?
Judge, could I ask one more? I hear you talk about the number of cases and the number of employees I think you mentioned earlier or that work for you. Is that sufficient? Do you have sufficient staffing to do what you need to do for referrals and home visits? Is that a problem?
The breadth of the mandates for the child welfare system at this point in time exceed our resource capacities. And I think that one of my recommendations for the task force, or my requests, would be for the task force to take a look at what the primary functions and responsibilities of the child welfare system should be. I've worked in this system since 1985 in many different capacities at the county level. And I've seen our primary roles of protecting children, supporting their families, diminish through the years because of other kinds of mandates and requirements. And while all of that might be perceived as good for children, I'm often uncertain as to whether or not those additional mandates allow us to focus on our primary responsibilities.
Thank you. And Judge Grimm, you are not seen but remembered. Do you have any questions?
Actually, I do, and it's kind of born out of the last question that was asked, Mr. Chairman. First of all, an extraordinarily impressive presentation, particularly your outreach to the community. But the area that causes me at least some concern is the perception, if not the reality, that the children and youth workers that are in the front line are subject to considerable turnover. So my question is with regard to adequate resources for purposes of hiring, training, and retention of your personnel, whether there's anything that you would recommend to this task force in that area.
Judge, thank you very much for that question. I think it's a very important one. The caseworker's job is very, very stressful. It's not a 9-to-5 job. I think not a day goes by when caseworkers are not working beyond their required hours. In fact, many contacts have to be made at night, particularly as there are more single-parent working homes and two-parent working homes. We don't just see who is available at the home. We see all those family members. So it's a stressful job. Families don't often welcome us and invite us in to have coffee when we make that first knock on their door. And while the requirements for casework positions, at a minimum, our requirement in Montgomery County is a bachelor's degree. We have many people who have master's degrees as well, but the pay structure is not consistent with those in the private sector for bachelor's and master's level positions. The stress of the job, I believe, as well as the salary structure, can be a real deterrent for folks who might have the necessity to move on after a few years. I believe that our training program in the state of Pennsylvania has a wonderful certification program for new caseworkers. That process, though, for training of new staff often takes up to 6 months. So we make a significant investment in a new employee before they can actually get out there and hit the streets and do what we've hired them to do. And what, at that point, after 6 months, they're really burning to do.
Thank you. Anything further, Judge Graham?
Thank you.
Thank you very much. And happily, we did sneak a bit into our mission, what can we do better, but your appearance here helped us to get our feet on the ground. It is by no means intended to be exclusive in the sense that if you have other thoughts you would like to share with us, either in writing or quite possibly if you think that there are other aspects of this that you would wish to present on, we would love to have you back. So thank you very much.
Thank you. I so appreciate your time as well, or if there's additional information that I can provide, please, I would like to encourage you to contact me. I'm absolutely available.
Thank you. And let me just express my own thoughts on sort of time here. I was never good as a judge at getting done with people unless I thought, unless they were really driving me crazy, and then I'd start waggling my pen around. This presentation has been wonderful. I believe every one of them is. I'm inclined not to get too trammeled by time. Our staff already checked. I believe Mr. Sanders, who came a very long way to be with us, I'm told your schedule permits you to be here. So I'm just inclined to march ahead. At some point, maybe we can even take a little break just to stretch our legs. But I'm thinking we'll roll ahead and not be unduly worried about the times that are on this agenda. So thank you very much, Ms. O'Connor. And next on the agenda is Kathy Utz, and we, of course, of the Office of Children, Youth, and Families of the Department of Welfare. And unless, Madam Secretary, you have any other introductory remarks, the floor is yours.
Thank you. We're just going to short our presentation and still get in what we need to.
Well, that's, but again, unless I'm not seeing anybody who's saying, hey, wait a minute, I want to get to lunch, that we all came a long way we're getting into the meat of what we're here to do. So take what time you need, and we'll get out of here before the sun sets.
So I thought rather than go through all 51 slides, that I pulled out just a few, and rather than actually probably put them on the screen, I have a couple here that I was just going to hit pretty much the highlights, because I think that Mr. Sanders really has a lot of information that we all would be willing to hear and listen to. So I'd rather defer our time because the department will be around. He's traveled so far. I think you probably want to hear him more than maybe you want to hear me. So what I would start with is kind of slide 3 really talks about the Office of Children, Youth, and Families and a little bit about our structure organizationally. And it focuses on our Bureau of Child and Family Services. And we have 4 regional offices within that bureau who actually go out and license each of the county children and youth agencies. They license the private providers that deliver services on behalf of children and youth agencies. And that's only for placement services. We do not license providers of in-home service. We don't have that authority under the Public Welfare Code. So I wanted to make that distinction for members of the task force. It really is those placement providers that we have the licensing capacity over. Our regional offices each year license over close to 1,700 programs. And so within those 4 regional offices, they're doing that work with the staff that they have. And we have a license capacity for children in placement of over 15,000 places for them to reside. And in addition to doing the licensing and technical assistance work for the counties and providers, our regional offices also investigate reports of suspected child abuse when the alleged perpetrator is an agent of the county agency. So that would be a situation where perhaps it was a foster parent, it was a residential staff member, it was someone, maybe perhaps an employee of a county agency or a private provider. And so those investigations are done by our regional office staff as well. And in 2010, they did over 2,000 investigations themselves across the Commonwealth. Additionally, the regional offices also are responsible for conducting the child fatality and near fatality reviews that are required under Act 33. They do those reviews within 6 months, and they are also participating on each of the county Children and Youth Agency Act 33 review teams. They sit as members and they listen to the cases as they're being discussed within the county, and the county has 90 days to complete their reports on those cases. Additionally, our regional offices are really focusing on making a shift in looking at the quality of services that are being provided within our system. We recognize that we're responsible for the licensure and looking at making sure we meet regulatory compliance, but we've really begun to look at making sure that the services that we're delivering through counties and providers are of quality and they're actually providing better outcomes for children and families. And so in 2010, we started a quality service review process whereby each county within a phased-in period of time, probably over the next 5 to 8 years, we would be doing quality service reviews where we look at a core set of elements that really aren't looking at necessarily did you dot your I, did you cross, did you dot your I, did you cross your T, did you do a plan within the time frames, but really looking at those plans and saying, you know what, the plans are focused on really achieving outcomes for children and families moving forward. Moving away from really a paper-based process where we're just looking at records to really talking to families, talking to children, talking to providers, talking with the court to find out, do they all have a common vision for that family that they're providing services to? Are they functioning as a team to make sure that they're moving in the right direction? We are currently doing those reviews in 11 counties within the Commonwealth. This is our second year, and all the counties are really receptive that have been part of that process. And so what we're doing then as far as licensing is we're taking those same cases and we're applying certain pieces of our licensing regulations that focus really on the safety components and the health components, and then so it's an abbreviated licensing and really more focused on the quality pieces. So that's been something that we're extremely proud of. With the support of Casey Family Programs, we've been able to actually roll that out within Pennsylvania. And our focus is really on sustaining lasting change in counties and providers and within the Commonwealth, because we recognize that what we were doing in the past really wasn't having a lasting impact. Dr. Christian really talked about the cases that continue to come back to the system. And so really this provides us with the opportunity to be able to look and say, why do families continue to come back? What are we doing well within those families that are preventing them from coming back to our system? And then how can we take what we're learning about what we're not doing so well and really lead to systems improvement and lasting change? We also then have, on slide 6, we talk about the Bureau of Policy Programs and Operations, and that's the bureau that I actually am responsible for. And within that bureau, we have 2 or 3 divisions that are focused on development of policy from, child abuse and neglect up through adoption, and then the regulations that support that work. We also have the Division of Operations, and I think that folks are probably most familiar with that. In that's where our state's child abuse hotline, Childline, is housed. And in 2010, we received over 1,222 calls to the hotline, and 40,000 of those were referred to counties as General Protective Services cases, and then 24,000 were referred to counties as child abuse cases. Additionally, we we'll get the calls that Ms. O'Connor talked about as well, that are specific to cases where the perpetrator is not a perpetrator under the Child Protective Services law, and we refer those directly to the district attorneys in each county, and we provide a courtesy notification to the County Children and Youth Agency on those cases in the event that they may be familiar with that family or working with them for another reason. And we made over 3,000 referrals to law enforcement officials in the counties as well in 2010. Part of that responsibility really changed in 2006 with the passage of Act 179 that required not only Childline to take child abuse cases, but when it really changed to say that we would take all referrals on child abuse regardless of who the perpetrator was. And that's when we actually saw an increase in the number of calls that we were receiving at the state's child abuse hotline, because all the criminal matters were also coming to us as well. We also are responsible within the Division of Operations for all the child abuse clearances that are conducted. By statute, we're required to complete those within 14 days. And I get a notice each day about what day we're on. So like yesterday, we were completing them within 11 days, so that was kind of higher for us. But generally, we complete those clearances within a week. One of the things that I also wanted to point out is that in November, we had a significant increase in the number of calls to the state's child abuse hotline, particularly after the firing of Coach Paterno. And we had days where we had probably actually our rate increased by 110%. So we really struggled to answer the calls that day. We did, miss a lot of calls, but we put a plan in place where we met on a daily basis to talk about the number of calls that we were receiving, what we were going to do. We had to mandate overtime for our staff. We have 39 caseworkers who take calls on the child abuse hotline. And then we have supervisors, obviously, who supervise their staff. They were also taking child abuse calls. And we had a plan whereby if we had gotten to where we were missing 9% of our calls on a daily basis, that we actually had staff within our policy division who were going to begin to take child abuse calls. I'm happy to say that we've actually decreased, and we're running probably about 5% right now in the number of calls that we're missing, so that's down from where we had been. One of the things that we've been doing is we look kind of like hour by hour in when we were getting calls, and we were trying to predict a pattern to say, is it first thing in the morning? Was it right after lunch when professionals came back? Was it at the end of the day? And just when we thought we had a pattern in place, something would come and it would change. And so we found that it was really just caught all over the board. And if we began to plan for calls maybe at 9 o'clock in the morning, then they'd start to come at 1 o'clock. And so we really paid attention now and tried to do the best that we could to figure out how we manned that. We did have staff that were coming in, and we had changed some shifts around. So we continue to do that. I meet with our Childline supervisors every other week right now. We're talking about what we need to do and how we can actually make some systems changes to decrease that. Our threshold of where we would like to be is no more than 6% of our calls are dropped each day. We do see, I think, the same thing that the county's experienced, that if we are having staff vacancies, then we struggle more so than when we have our full complement of staff. We currently have one vacancy for a Childline caseworker right now that we're hoping to fill in the next few weeks. So. Yes.
Just a quick question. So that 100% in increased calls, was that 100% of calls because of additional concerns of child abuse, or were it people who were just yelling at you?
It was a combination of both. We did get some calls about how we were the kind of the worst state in the nation and how could we let this happen. So we did receive a fair share of those. But then we're really liking it to that after Coach Paterno was fired, I think that we saw that increase because people thought that while he may have followed what was in statute, that he was fired because he morally perhaps didn't do what folks thought that he should do. And so there was a kind of a public cry, I think, that people were afraid that that might happen to them. And so we did see a spike, and then that has since declined, and we're back to kind of our normal level. We're also then responsible for the operation of the Interstate Compact for children. So any child who leaves Pennsylvania or comes into Pennsylvania for placement purposes within the child welfare or juvenile justice comes through our division of operations as well. And then we're also responsible for overseeing all the grants and contracts to counties. So our role is we actually do provide services to the Commonwealth's constituents, but we also really function more in an oversight capacity for counties and private agencies. I did mention, and I have slides in here that talk about the definition of who a mandated reporter is on slide 25 and 26, both before Act 179 and then after Act 179, because it really changed not necessarily what was reported, but when it was reported. Because in the past, it was you had to have a reasonable cause to suspect that a child coming before you, so the child physically had to be before the mandated reporter in order for them to actually cause that report to be made. And Act 179 then changed that and said that it had to be a child who was under the care, guidance, supervision, or training of an agency. And so no longer did the child just have to come before them, but they could hear information third hand, and if they had reasonable cause to suspect based upon that information, then they were mandated to report to us. I also included in slide 27 and 28 additional reporting requirements for mandated reporters that you can take a look at, because I know that is part of the focus of the task force. On slide 32, we really talk about the federal outcomes and measures that we're held to and the things that the federal government looks at when they come in and do their Child and Family Services review for us. And they are obviously that children are first and foremost protected from abuse and neglect, and that they're maintained within their own homes safely whenever appropriate. That they really have permanency in their lives, that when they come into the child welfare system, that we do everything that we can to get them home in a quick manner, and if we can't, then that we find permanency for them in another way. And that we're also looking then at their well-being outcomes, so making sure that they have their educational and physical and behavioral health care needs met. Some of the strengths that I wanted to talk about from our Child and Family Services review that focus on safety really relate to the timely response to reports that county children and youth agencies and the regional offices were getting out to families in a timely manner once they received the report. Lori talked about some of the time frames earlier. That many of the counties had expedited responses for children who were younger, and that we had a strong array of services to meet child and family needs, and that we completed risk and safety assessments on a regular basis, and that we had a low recurrence of maltreatment. Some of the safety concerns were related to if we had a case that started out as a general protective services case, but over the course of time, it may have ended up being a child protective services case or a child abuse case. We weren't always as quick in transferring that case from a CPS to a GPS as we should have been. That the number of reports of children who were abused in out-of-home placements was concerning. And that while we were doing risk and safety assessments in a timely manner, that they were focused primarily on looking at presenting problems rather than underlying issues. And so we believe that that likely would lead to those recurrence in those GPS reports continuing to come back. So our focus really has been now on looking at finding better ways to address those underlying issues. As a result of the Child and Family Services review, we had to complete a program improvement plan. And it was really focused on child, youth, and family engagement and case planning, because we've talked about some of the family engagement strategies that we're employing, and we believe that if we do better family engagement from the start, that then families will be able to respond more appropriately to services and become healthier as we go along. We need to focus in ensuring that we're providing timely permanence to children, particularly children who were going through the adoption process. It was taking us a long time to have children who did have a goal of adoption to actually then have them adoption. Once the parental rights were terminated, we did a good job of making sure that the adoption was finalized, but it took us a long time from the point in time where the goal was changed to actually get to that point. And then I briefly talked about sustaining change. And the last slide that you have, slide 48, is really focused on our process for driving sustaining change. We had a Child and Family Services review in 2002, and then we had another one in 2008. And what we found was that many of the things that were noted as areas of concern in 2002 remained the same areas of concern in 2008. And we took a look at the program improvement plan that we had developed as a result of that 2002 review, and it was really a compliance and task-focused plan that said we would issue policy, we would do certain things, but that it really wasn't focused on making the change at the local level. And so we worked with, through our partners with Casey Family Programs and the American Public Human Services Association, to adopt a model of really defining where we want to go as a system. And we're doing this in each of those 11 counties where we're doing the quality services review, assessing where we are, developing a plan that provides us a roadmap for how we're going to overcome our current barriers and challenges, implementing, obviously, those plans, and then monitoring those through the quality service reviews that I mentioned earlier. And then we start the process over so that it's a circular process rather than a linear process, which many of our efforts have been to date. So with that, I hope that was a brief overview for you.
Kathy, can you talk to us a little bit more and define for us what a missed call is in Childline, but also you mentioned drop call.
Yeah.
So is there a difference?
So we categorize two different types of calls. We have abandoned calls, where a person will call, they will get into the queue so that they will be kind of on hold, and then they terminate the call on their end. And then we have missed calls where the person never gets into our queue, so they never ring. We know the number of calls that people are calling, but they are totally dropped. They never get to even in the queue.
Is that because our capacity to handle those calls, so we just have way too many in the queue at certain times, and so we never get to them?
Yes.
Okay.
Could we turn to page 28, please, of your slides, which you didn't highlight, but I think we might want to spend just a minute or two discussing?
Certainly.
Because it's the reporting with institutions part of reporting laws. And I think that there was some concern kind of in the Penn State situation where individuals were reporting up and then and then obviously the whole system collapsed. And I assume that people would want to look at that part of the law, although I will say coming from a hospital system where we think we have a decent system for reporting, if you were to mandate that every person in this institution who knew of a possible child abuse case was mandated to report, you would get, at Children's Hospital of Philadelphia, potentially 45 calls about the same child.
Yes.
Because so many people touch that child at the hospital. So could you just review this part with us, and if you have any suggestions for kind of where this you think this might best live, or how it should work? Thanks.
Yeah, I can review it for you. What this really says is that within an institution or a school, that each of the schools or institutions has to have a process in place whereby they determine how the report gets made to Childline. So that if it is a teacher or perhaps a nurse, there's one generally central point of contact for teachers, nurses in institutions that they will talk to, who then is responsible to make the report. And so I think that, Dr. Christian's correct when she says that it seems like it's a good process because you have one central point of contact. We're not going to then get, numerous calls on the same call. I think we've seen also the converse, where there have been situations where folks didn't make a call. You have a mandated reporter, a teacher or someone who really thought and had concerns, and they may have let their principal know, and then the report didn't get made because the principal may have said, well, I don't know that it happened, or they didn't talk to the child. So I think that there's pros and cons probably to both, and I think it would warrant, a further analysis and walkthrough of what those pros and cons for be, because I think that it could, work in either way, and I've seen both sides. We've had a lot of folks who then have been concerned, mandated reporters who will come to us and say, I'm concerned. They may not have a closure loop that initial mandated reporter who saw the child, that they may never know within their institution whether the report was actually made. And we hear from them that they want to make sure that they're fulfilling their duty and that they're fulfilling their responsibility, so they go ahead and make the call. I think some of the increases that we actually saw in November, some of those were related to a mandated reporter who made it within their institution, and they said, I'm calling anyway. And so I think that there are, policies and procedures in place. I think some may fear retaliation if they don't know that their principal made the call and they make a call anyway, even though the statute very clearly says you can't have retaliation in those situations. So I think there's probably pros and cons to the way that it is.
Okay, and then I have one other question, and then I'll turn over. When in the CFSRs where we have strengths that include repeat maltreatment was low, part of my concern is that our GPS system is not counted.
Correct.
Right? So, and I think everyone on this task force needs to understand that if you look at state-by-state statistics, Pennsylvania looks like as I always say, the kindest and gentlest state.
Yes.
Because we have maybe 1/10 of the child maltreatment as any other state, because GPS doesn't get counted.
Absolutely.
And so when we say repeat maltreatment was low, could you define that? Because I think it really refers to maybe CPS and re-CPS reports. And again, it kind of goes to like how these two systems work or don't work together.
Yeah, and I think that's exactly what it is, that Dr. Christian, it includes only CPS cases. It does not include GPS cases. And as Ms. O'Connor, talked about earlier, currently we do not have a statewide system that gives us that data. Because I must tell you, I came to the department 13 years ago, and one of the first questions I asked was how many children start out as GPS cases and how many of them end up becoming CPS children. And we couldn't answer that question. So it's been a question that I've been wanting to answer for 13 years. And we're well on our way to actually having a system. Ms. O'Connor talked a little bit earlier about how we spent the last 2 to 3 years really trying to make sure that every county children and youth agency had a system in place, and that our eventual plan is that we will take the information from each of those systems and put that into one statewide system, and that we'll be able to get information. We just talked with a county earlier this week who was working on their system, and they can do some of the things, and they were talking about these orange cards, and they talked about how they're just moving to an electronic system, and they had orange index cards. And that's where they kept most of the information, that was key on their families, and everybody talked about the orange card, and they went back to it. So, I think it's pretty concerning that in 2012, with a state the size of Pennsylvania, that we don't have an electronic record for our child welfare system, but we're on our way.
Okay. Thank you.
Ms. Hutz, again, thank you for what you do. I've known you for a long time. I have 3 questions. Who can access the Childline database for clearance purposes? So, in other words, is there somebody that's other than a DPW employee that can access Childline to check for a clearance?
No, because the information, the Child Protective Services law requires that information is confidential. It can't be accessed by the public. So that right now we have a paper-based process where an individual, an applicant, submits their request for a clearance to us on paper, and we send it back to them. Because you can only exchange information with certain individuals, and so we just can't go out, and it's different than the crimes, because the crimes are public information, and therefore you can access those usually through AOPC's website or the state police website. But we're not permitted to do that because that information is confidential.
Follow-up to that, so law enforcement can't tap into Childline database.
They cannot.
Is there a fee associated with that screening process to the individual seeking a clearance?
Yeah, the child abuse clearance, for the department's child abuse clearance, it's $10. There's also a state police clearance that folks, if they're getting employment, have to pay, and that's $10 as well. And then there's an FBI clearance that we do electronically, and that's approximately between $35 and $40.
When calls come into Childline, is there a process by which those calls, incoming calls, somehow are prioritized, in particular for those that are characterized as mandated reporters? In other words, if Dr. Christian were to call in, would her call be received perhaps before my call? In other words, is there as it should be?
Anything for Dr. Christian. We've known her for a long time, too. No, we don't know who's calling, up until the point in time where we say, hello, Childline, and they tell us who they are. So there's really not a mechanism for us to be able to do that unless we had caller ID with everybody's names, and we would know that it was Dr. Christian calling, not you, and then we would take her call first. Yeah. But no, we really don't have the capacity to be able to do that until you know who's on the other end of the call. One of the things that we've been trying to do is everybody calls the hotline because that's the number they know. So they call that number if they want to, have a question about their child abuse appeal. They call that number if they have a question about their clearance. But we do have other phone lines that are dedicated to taking those calls. And so we just recently were able to include in our system if you're calling to report child abuse, press 1. If you're calling for a clearance, press 2. If you're calling for something, an appeal, press 3. And so that we were able to actually implement that, to be able to dedicate our resources that are actually taking the child abuse calls to that and diverting others to the staff that handle the appeals. But that's the number that everybody knows.
And then my last question, just to talk about the way mandated reporters, as I understand, the initial requirement is an oral report. Mm-hmm. Am I also correct to understand within 24 or 48 business hours there needs to be a written report that's logged by the mandated reporter?
Right. So there's a requirement in the statute and regulation that says within 48 hours of the oral report that the mandated reporter has to submit the written report, the CY-47 as it's called, to Childline, and then we send that to the counties as well. And
then when the investigation is ultimately concluded, am I also correct to understand that that mandated reporter is to know the outcome of the status of the outcome, whether it's indicated or founded, yes, or unfounded rather, indicated or unfounded, that is communicated to that mandated reporter? That
it's not communicated on a consistent basis by counties, but that yes, there is the statute does permit a mandated reporter at the conclusion of the investigation to get the status determination as well as whether any services were provided. Did you have another question?
It just occurred to me that, if you wanted a triaging system within phone calls to Childline, you can repeat your press button 1 if you are from a doctor's office or a hospital, press button 2 if you are this or that. So since you have the capability, you could just do another round.
Thank you.
You're welcome.
Yes.
I've earned my lunch.
Hello, you did a great job.
Thank
you. I
you.
just have a couple questions about Childline.
Sure.
I read in some of the materials that there is a Senate bill that's being proposed to upgrade the phone system that you currently are using. What is the status of that? If you don't know, maybe staff can find out.
We actually work with our Bureau of Information Services on the upgrade, and we were just told that that was put on hold. Again, because we're looking to do something a little bit different, and I think it goes into the procurement process. So right now it's been on hold.
And so the type of thing that you're considering doing differently, would it be more computerized so that paperwork would go faster to the counties or to law enforcement? Yes. So it's more of a comprehensive overhaul than just changing the phone system?
Absolutely.
Is that fair?
Yeah, one of the things that we want to really be able to do is transmit the reports of suspected child abuse electronically back and forth between the department and the counties, so that it provides, less duplication of effort for us as well as for counties. Because what happens now is we may have, particularly in some of the larger counties, we may have 3, 4, or more reports. And what we'll end up doing is we'll call them and we'll spend perhaps sometimes a half hour actually calling them to talk about each of those reports, depending upon the number. So having the ability to transmit that securely between the department and each of the counties would, I think, save us time as well as save counties time as well. And we would build in an alert, obviously, that said you received a new report from Childline. It would also give us then the opportunity and the ability to be able to track those GPS cases over time, and as Ms. O'Connor mentioned, for counties to be able to see records of families who have moved across county lines, which we believe is critical as well.
And so if your project is on hold, is there a time frame that has been given to you in terms of when it would be anticipated to be implemented, or is it on hold from your end because it's so comprehensive, or is it on hold from a funding end?
No, it's just the phone system upgrade that is on hold.
Okay.
Our IT and our larger child welfare information technology strategy is not on hold, and we're progressing with that.
And then as far as the caseworkers that actually handle these calls, do they also have bachelor's degrees?
They do.
Okay. And are they mandated to go to any sort of trainings on a regular basis, or can you just tell me a little bit about who they are or what they do?
Sure. Many of the caseworkers who work at Childline likely have come from other county children and youth agencies, and they come to the state because we were paying more than some of the counties were paying, so that they came to the state from counties. So they came to us with, a certain level of experience already. We also get staff who are current state employees who are transferring within the state Commonwealth system. We do have a training period for each of them before they go on the hotline. So we do, and it's approximately 3 weeks where we sit down and we do just on-the-job training where we talk to them about roles and responsibilities, what the child welfare system is about, what they need to do. And then they actually are paired with a supervisor. And the supervisor will take the Childline calls, and they will listen to the supervisor, interact with the caller, and then it's a point in time where that will then flip, and the caseworker will begin to take the calls with the supervisor there continuing to manage. And so once we feel comfortable and the supervisor believes that the worker, is asking the questions, and we have a standard set of questions that we're, asking for on each call. And once the supervisor feels that they're comfortable with the worker and the skills that they've progressed, then we will put them on the hotline alone.
Okay, great. Thank you.
You're welcome. Thank you.
Mr. Chairman, it just occurred to me, and I don't know if you can answer this, Kathy. I think you can. Is there a mechanism once the county or DPW receives the initial referral of suspected child abuse to begin the investigation? Is there a mechanism that goes out to potential employers of the alleged perpetrator? And I know this is not about the Sandusky debacle, but and this is much bigger. But are there notices that go out to in those situations where the alleged perpetrator is engaged, and where the alleged perpetrator is engaged with children on a regular basis? Is there anything that happens there?
So I'd answer that in 2 ways. If the alleged perpetrator, it's a child abuse case where a person works in a child care setting and they have allegedly abused their own child, we are not permitted by statute currently to notify the employer of a pending investigation, nor can we let them know at the end any of the results. Where we are permitted to have a conversation is when the person who is alleged to be the perpetrator, if they are working in a child care service, that child care service has to then have a safety plan in place for how they're going to assure the safety of not only the victim child, but also all of the other children in their program. So in that situation where the abuse allegedly occurred in a foster home, in a residential program, they would be aware of it in those situations, but not if it was an employee who allegedly abused their own child.
If I could just to follow up, if the referral comes in, maybe the individual works in two different settings. The allegation is the perpetrator committed an alleged incident of child abuse on a child within setting number A, employment number A, letter A, but also that individual happens to be engaged in setting number B, which also is engaged with children. Is there a way to reference and notify agency or entity number letter B?
No, we would be able to work with agency A, but we are not permitted to notify agency B.
Judge Grimm, any questions from such?
No, thank you, Mr. Chairman.
All right, thank you. Thank you very much for your abbreviated but very helpful presentation. And, of course, we have your whole packet of materials of each of the panel does. Are we good to march along? Anybody need a break? I see. Seeing none, I'm not going to ask twice. Mr. Sanders, you have been very patient. The Casey Family Programs has done and is doing great work for children in this and other states, and you have come a long way to be here. We appreciate that and your patience.
Thank you.
I'm
actually very excited to be here. So I want to first begin by thanking the task force, and I'm actually not going to just present a national picture of child welfare, but really to try and put Pennsylvania's practice, policy, and performance in a national context, to just look at how these policies, practices, and performance compare nationally. And hopefully we'll really end up supplementing some of the information, excellent information from Lori O'Connor and Kathy Utz. As mentioned, I'm David Sanders, and I'm a Vice President with Casey Family Programs. And for those of you not familiar with Casey Family Programs, we're headquartered in Seattle, which is the long trip that I took, although I was coming to Philadelphia tomorrow anyway. And we are the largest foundation in the country that focuses exclusively on foster care and child protection. We were founded by the UPS founder, Jim Casey, and have been in existence for more than 40 years. And I'm actually responsible for our work in states across the country and our work in federal public policy. I'm going to give just a quick overview of the presentation, which is on this first slide. I'm going to touch on the work that Casey does in the Commonwealth of Pennsylvania. Second, I'll give an overview of the regulatory structure for child protection with a particular focus on the federal government, although I'll touch some on the regulatory structure in the Commonwealth. Then for the next 4 sections, I'm actually going to compare with other states. So we'll put it into context compared to Michigan, Ohio, New York, and New Jersey, and then in some cases kind of give a national picture. And really, again, to try and put Pennsylvania in that national context. So I'll talk about mandated reporting, who's required to report, what must they report. I'll talk about the assessment and investigative process, what happens to a report, again, in a context compared to other states, what constitutes child abuse, and then finally talk some about Pennsylvania performance. And I believe that the task force will ultimately focus on reporting and investigation, but really want to give a picture of kind of what happens to a child who comes into the system in Pennsylvania, and particularly, again, compared to the other states. So first, the work in Pennsylvania that Casey Family Programs has done. And just a couple of points that I want to make. First, that Casey has made a significant investment in Pennsylvania over the last 5 years. Our total investment is almost $9 million in that time. So we really are invested in the success of this state and the success of the child protection and foster care systems. We're also committed to continuing that support. And if the task force needs anything that might help to improve your deliberations, we're certainly happy to serve as a resource. In addition, I want to emphasize that in my experience, Pennsylvania has some incredible leadership in child welfare and foster care across the state. You heard from Kathy Utz, obviously the leadership that Bev McArith has provided from DPW. We've worked closely with Anne Marie Ambrose in Philadelphia and Mark Cherna in Pennsylvania, and they are really two acknowledged leaders in the country in child welfare. Joan Binso with Pennsylvania Partnerships for Children, I think, has been an incredible resource for the Commonwealth. And Justice Max Baer, who has provided some strong leadership from the court. And obviously you heard earlier from Lori O'Connor and kind of her excellent overview. And I would just urge that you continually seek their counsel as through your deliberations, because they really are excellent. And then finally, I would just touch on, you see that part of the work we've done in Pennsylvania is with Philadelphia, that I have had the privilege of serving on the Philadelphia Community Oversight Board along with Dr. Christian, that is responsible for overseeing the work of the Child Welfare Agency in Philadelphia. And so I'm here on a regular basis. I'm certainly not an expert in the work in Pennsylvania, but have learned a lot and have been very pleased to be able to contribute. So let me switch to that second section, which is the regulatory structure. And you heard a lot about the work in the counties and the work in the state. Let me just step back to give a sense of what the federal government mandates. And that really, this is a very high-level overview, but the federal government really mandates certain activities but provides a flexible foundation. And I'm going to touch on three things that the federal government particularly emphasizes and focuses on. One is the federal government really defines a minimum set of activities or behaviors that define child abuse and neglect. And the key point, and this point was made by both Lori and Kathy, that the focus is on abuse or neglect by family members or caretakers from the federal government perspective. Second, the federal government mandates that states have an ability to respond to abuse or neglect complaints and also define some of the services that states have to provide. And so, for example, the structure for receiving and investigating abuse and neglect reports is really required by the federal government. It's not defined what it looks like, but there has to be a structure in each state. And it also defines services up to and including removal of children from their families. Again, many of the services are related to family and what's needed to assure safety for children within a family context or with caretakers. And examples include, and Lori touched on these, family preservation services, placement, termination, and adoption really are defined under federal statute as duties for the system. And then finally, and this was again touched on, the federal government defines desired outcomes for children, safety, permanency, well-being, with safety being the priority. I'm not going to go into great detail in this because it's been touched on several times, but Pennsylvania is a state-supervised, county-administered state, and that's actually a relatively unique structure in terms of the number of states that are state-supervised and county-administered, with counties having the responsibility for delivery of most services. And although many of the large states have that same structure, and I would contrast that with state-administered and delivered systems where the state has full responsibility for delivery of services. And I'm going to come back to this because it does impact the data, it does impact policy and the role of the state. But in the slide specifically, the Commonwealth defines civil statutes define child abuse and neglect, and that's been talked about before. The focus is on action by parents, guardians, et cetera. That's been touched on. The one exception, obviously, is licensed providers, because there is a remedy if licensed providers aren't meeting their obligations. So daycare providers, as an example, that the child welfare requirements govern. Criminal statutes obviously define offenses and provide penalties for crimes, and usually involve persons who are acquaintances and strangers, in addition to parents and caregivers. And then finally, law enforcement agencies, not the child protection agencies, respond to reports of criminal acts. And Lori touched a lot on this, but I did want to emphasize this in the next slide, because I think one of the key issues that I want to touch on, and we'll come back to, is the overlapping role of law enforcement and the criminal justice system and child welfare and the dependency system. And this is just an example, but I think the work described in Montgomery County is obviously really very advanced in looking at the interagency team. And I think this is really important for you to consider in your deliberations. Law enforcement obviously has a role to investigate and to try and determine if a crime occurred and who perpetrated the crime. Within child protection, the responsibility is to determine abuse and neglect, to provide services to assure safety. One distinction is it's not necessary to identify a perpetrator in order to determine that services are needed, and the focus is generally on family and caretakers. That area of overlap might call for a dual investigation, and certainly that occurs in many cases in Pennsylvania, where the criminal act is perpetrated by a family member or a caretaker. And so that's the area of overlap. I think it's really critical in as you look at the child protection system to keep that overlap in mind. This has been touched on several times, and Dr. Christian raised a question about CPS versus GPS. And there's a couple of things that I want to emphasize on this, that no other state makes this distinction. So this is unique to Pennsylvania, that there is a CPS-GPS distinction. Other states' statutes define abuse and neglect and a response, and don't have two distinct categories and two separate responses. So I'm going to come back to this, but I think this is a critical distinction and something, again, to consider in your deliberations. Some of the impact is on the data that you'll hear and that you've already heard. At a national level, the National Child Abuse and Neglect data is one of the sources of information that I'll refer to throughout here. And this was a question that Dr. Christian put to Kathy Utz, that in Pennsylvania, the reports classified as CPS are captured in that data. The number of maltreatment reports are lower in Pennsylvania because some children go through the GPS system and not through CPS. The measurement of repeat maltreatment, which again was raised earlier as a question, is specific to substantiated reports of child abuse, so CPS and not GPS reports. And then finally, the mandated reporters have to report suspected child abuse. There isn't the same mandate to report GPS cases. I should mention that much of this is information that we've been able to gather nationally, and I would certainly look to Kathy Utz to correct me if any of this is incorrect, because sometimes what you read isn't exactly as it appears. But it is clear the distinction between GPS and CPS is unique to Pennsylvania. So that's the regulatory framework. Let me move into mandated reporting. And again, we'll give a high-level summary, but using it primarily to compare to other states. So who's mandated to report? Let me just mention for the states that are on here, they're obviously similar size in terms of population, but New York and Ohio are also state supervised and county administered, so have a similar structure to Pennsylvania. New Jersey and Michigan are actually state administered, so have a different structure than Pennsylvania. And I'll come back to that, but that's an important piece to keep in mind as you're reviewing any of these. And as you can see, the Pennsylvania, in terms of who it defines as mandated reporters, looks very similar to the other states, with the exception of New Jersey. And New Jersey is one of those states that actually identifies everybody as a mandated reporter. So it's not just certain professionals, but everybody in the public is identified as a mandated reporter in New Jersey. What mandated reporters are required to report, and you can see here generally it is a reasonable cause to suspect child abuse or neglect, or some language similar to that. Going back to the GPS, CPS, Michigan, New Jersey, New York, and Ohio all require reports of suspected abuse or neglect into their hotline. Pennsylvania requires reports of suspected abuse, and as both Lori and Kathy mentioned, serious physical neglect is included, but it's much narrower than neglect in other states. So the other 4 states, when we look at what mandated reporters are required to report, actually are required to report a broader array of behaviors because they're capturing neglect much in a much wider net in neglect than would be the case in Pennsylvania. This is just a comparison of the penalties for failure to report for mandated reporters. And as you can see, generally it is a misdemeanor and pretty consistent across the 5 states for failure to report. And again, this has been touched on in several ways. The state-administered states, Michigan and New Jersey, county-administered are New York, Ohio, and Pennsylvania. The reporting varies a bit across the states. Actually, although Michigan is state-administered, the requirement is to either the local county or to a statewide hotline. New Jersey and New York have a reporting to a central intake hotline. Ohio to either the Child Services Agency or the law enforcement agency in the county that the child was abused. And then Pennsylvania, the reports do go through the central hotline, although reports can come in through counties. The Pennsylvania also, and this was touched on in the, I think it was page 28 of the information that Kathy Utz presented about employees of an institution. And so obviously staff members of an institution are required to notify the person in charge of the institution, school, facility, or agency. Just again, putting it into comparison, New York has a similar structure and similar statute where the same requirement exists to report to the chain of command in the institution. Michigan has something similar, but Michigan also requires that the employee report to the Child Protection Agency. So they have both responsibilities, to report to their chain of command, but also report to the Child Protection Agency. And Ohio and New Jersey have no staff-specific provisions, so anybody who's a mandated reporter has to call into the hotline. So it's a different structure across the 5 states, and Pennsylvania does look like New York. The others have something that's slightly different. So let me move into the next section of really looking at the assessment and investigative process. So what the county is required to investigate and what they do in some ways is, in many ways, is determined by the definition of abuse or neglect. And as I've mentioned before, the GPS distinction is important. But within that distinction, there's something else that I want to highlight, that actually Pennsylvania also has the narrowest definition of physical abuse. So and that's because Pennsylvania in the law defines serious physical injury as an injury that causes severe pain or significantly impairs a child's physical functioning either temporarily or permanently. Other states don't have that reference to severe pain or significantly impairing the child's physical functioning. So once a report comes in, the definition in Pennsylvania is still a little narrower than the other states. And the definition of child abuse and sexual abuse or exploitation have been touched on previously. You can read the language here. I'm not going to go into detail on that. There's hopefully a hard copy handout that you have that you can refer to that just talks very quickly about across the 5 states who the responding agency is and the timeline for responses. I'm not going to go into that, but again, what I would touch on, and I believe that this was mentioned earlier by Kathy Utz, that Pennsylvania at this point only requires the timelines at a state level for the CPS investigations. And so I believe that there's policy change in place that will change that, but the focus, at least historically, has been on the timeline focus for GPS. And so other states, again, require timelines for all of the cases, Pennsylvania for the CPS only. This is referencing again the role in law enforcement, and I think is a critical element, and I would really support what Lori mentioned about the strength of the multidisciplinary team assessments. About 30% of states, including Michigan and Ohio, have actually no state provision for joint law enforcement CPS investigations. 55% of states, including New Jersey, New York, and Pennsylvania, and you heard some of the structure in place in Pennsylvania through Montgomery County, does provide a coordinated CPS law enforcement investigation. And it seems, given that area of overlap, that's something that's absolutely critical to have. And then actually about 14% of states have, law enforcement has the responsibility for investigating and or making determinations about removal of children from their homes. So it does again vary across states, but that consideration of the overlap between law enforcement and child protection seems to be a critical component. So all states have the responsibility to investigate, and so in walking through the previous slides, the issue of responding to abuse or neglect with an investigation is a requirement. Generally, and I think you heard from both presentations, the investigation results in a determination of yes or no, did child abuse or neglect occur, and then yes or no, are services needed. And so that really is a result of the investigation. Some states offer an alternative process for lower risk reports. And I would distinguish that from GPS and CPS in that there is a determination that the report is actually a lower risk report versus a distinction based on definition of abuse versus neglect. And so actually about half of states have respond a different way to lower risk reports. Don't necessarily do a pure investigation where there's a determination did abuse or neglect occur and are services needed, but do a response that states refer to as alternative response or differential response, where they determine if services are needed primarily and really look at the lower risk cases as not necessarily needing the formal investigation, but really needing an offer and determination of services. Michigan, New Jersey, New York, and Ohio have piloted or are currently implementing some form of that differential response or alternative response. In Pennsylvania, the distinction is a CPS-GPS, but it's not quite the same as an alternative response structure. So I talked about the definition of child abuse and neglect, and Pennsylvania both having the CPS-GPS structure as well as the definition of abuse or neglect, of abuse being somewhat narrower than other states. The level of proof to determine substantiation is also important. And actually, Pennsylvania and Kansas have the highest standard of proof for substantiating abuse and neglect. So you can see from the slide that the 32 states require a preponderance of evidence, 12 states require credible, 5 require reasonable evidence, and 3 have other standards, including in Pennsylvania, substantial evidence or clear and convincing beyond a reasonable doubt. So in determining for there to be a determination that abuse or neglect occurred, there is a higher standard in Pennsylvania than in some other states. So let me talk a little and really kind of closing on what does all this mean. This is actually, I think, a beginning to look at, so putting this into context compared to other states. So on this slide, actually, the dots are the number of children per 1,000 investigated. And you can see that Pennsylvania investigates fewer children per 1,000. Again, though, this is impacted by the GPS-CPS. So GPS assessments are not included in this number. So this is just the CPS assessments, but Pennsylvania investigates a lower number of children per thousand than the other states or than the national number. The substantiated in Pennsylvania, this is the national language, the federal language is substantiated. In Pennsylvania, it's indicated or founded in different language in different states, but the substantiation is the lighter part of the bar. And in Pennsylvania in 2010, and again, if these numbers are wrong, I'd look to Kathy to correct me, but there were about 3,600 substantiated cases of abuse or neglect in Pennsylvania in 2010. And as you can see, that number is far fewer in Pennsylvania. So Pennsylvania investigates fewer, substantiates fewer. Again, the CPS distinction is important in that, but New York is close to 70,000 substantiation. So there's a clear difference. Now, I want to be clear, though, that by showing this slide, it is not intended in any way to make a value judgment. The federal government gives states flexibility, and an argument can be made that focusing on the most serious incidents of abuse or neglect actually allows a state to utilize limited resources more effectively. So it's just presenting the facts, not necessarily saying that it means one thing or the other, but it is important information, I think, for the task force to consider. And really, any change that's made needs to be measured against the outcomes that result, the cost to families, as well as the potential cost to the Commonwealth. This is actually, again, I think, a reflection of, in some ways, of the CPS-GPS distinction and what results in terms of the types of maltreatment that occur in a state. So this is really looking across the 5 states as well as nationally. And you can see that other states, the primary type of maltreatment is neglect. And that's the vast majority in Michigan, New York, and New Jersey, and nationally. Sexual abuse and physical abuse are much lower numbers across most states. Pennsylvania, the percent of victims by maltreatment type, actually the highest percentage are with sexual abuse. And I think that reflects how Pennsylvania focuses on CPS investigations and what that means. And so I think that this is information that is, in thinking about comparisons across states, that most states structure their response focused primarily on neglect. For CPS cases in Pennsylvania, that's likely to look different because of how this is structured. Again, you have incomplete information because you don't have the GPS cases included this on a statewide basis. Let me just then move into the areas of Pennsylvania performance and look at what happens to children in Pennsylvania's child welfare system. So in spite of the low rate of reporting, the narrow definition of child abuse, and the higher standard of proof, Pennsylvania actually has a higher rate of children entering out-of-home placement than the other 4 states and than the national rate. And again, that's in part, I would presume, driven by the youth that are assessed by counties as GPS and may end up in care, and end up in care for reasons other than specifically child abuse. And I'm going to come to that in a second, but there's been a decline nationally in the number of children entering care, as well as a drop in the rate of entry and placement. And that's happening nationally as well as across the 5 states. One reason is that in Pennsylvania, actually on the slide on the left, that the percentage of children entering care for abuse or neglect, that actually in Pennsylvania, children are less likely to enter care for abuse or neglect and more likely to enter care for behavioral health reasons than in other states. And I think, again, that may in part be reflected by the GPS-CPS distinction. There may be other things that drive that. But when you look at the population of children in care and look at the reasons for entering care other than abuse or neglect, on the left side is the percentage entering care for neglect or abuse. On the right side are some of the categories. And so it certainly abandonment, inadequate housing, or parental substance abuse, or caretaker inability to cope may all be considered areas of neglect. So it may that they may or may not fall under the broad neglect, but you can see in Pennsylvania the percentage entering care for child's behavior is higher than the other states as well as higher than nationally, and so may reflect how counties are assessing GPS, may reflect who's coming to the door in Pennsylvania versus in some other states. The reasons that children enter care in Pennsylvania have the looking at abuse and neglect, looking at the other reasons, and looking at the total number of children entering care. Pennsylvania has seen a decline since 2005 of over 30% across all categories. So fewer children entering care today in Pennsylvania than 7 years ago. And so recalling, and it's been mentioned several times, the federally mandated priority is safety. In a couple of areas, Pennsylvania is actually doing quite well. And looking on the first slide, the children experiencing no abuse in foster care, although it's right at the national level, it actually is slightly better than the other 4 states. And the percentage of children with no maltreatment in 6 months, and this was talked about earlier, Pennsylvania does quite well, but again, part of that's driven by the definition of child abuse. On the right side is an area of concern, and I think a challenge for the state, and that's the percentage of children reentering care within 12 months of reunification. And as you can see, compared to the other states as well as nationally, Pennsylvania has some challenges in that area. Another area that Pennsylvania stands out in is the utilization of congregate care, including group homes or residential treatment, versus family-based care. And Pennsylvania, as you can see, has a much higher utilization of children in congregate care than the other 4 states as well as than the national average. As a matter of fact, it's almost double the rate of some of the other kind of similarly situated states. And that, as you can also see, that utilization is declining. And I think that there are some concerted efforts along those lines. But the use of congregate care, so what happens to children entering care in Pennsylvania, this is one of the areas that it looks different than in other states and jurisdictions, a higher utilization of congregate care. And then finally, the federal government directs states to assure that children who come into care exit quickly to permanency. And permanency really defined as reunification, termination and adoption, or permanent placement with a relative or kin. And Pennsylvania does relatively well compared to the other states, that in the percentage of children exiting to permanency to one of those options versus exiting to emancipation, Pennsylvania does well compared to the other states and is right around at the national average. And then percent of children achieving timely permanency, the federal guidelines are reunification within 12 months and adoption within 24 months. And you can see Pennsylvania exceeds the national averages in both of those areas and does well compared to the other states. So wanted to just give that overview, put Pennsylvania's numbers in context, and I will stop for any questions.
Pardon me, questions. Maybe let me start things off, and I'm interested because I have a theory in the crime numbers seem to be going down despite the adverse economic climate. Do you have any insights of the various sources and research you've seen as to why placements overall would be going down nationally?
Actually, you raise an interesting issue because the increase in placements that occurred through the 90s was attributed to increased incarceration rates, and that the increase in incarceration was the primary driver for increase in placements. And so I think that the correlation between criminal activity and placements is certainly high, and particularly compared to other kinds of correlation. So, for example, there appears to be, even though the economy is been struggling in most parts of the country, there's less of a correlation between a deterioration in the economy and placements. It does seem that issue of crime rates and placements, there's a very strong correlation.
David, thank you. That was really very wonderful presentation. And could we get a color copy of these slides, because we are actually missing a lot of data by looking at the black and white, and that would actually be very helpful to us. But I think in really looking at this data, it suggests to me that the dichotomy between CPS and GPS, but by having this dichotomy in CPS and GPS, and whether we want to keep the CPS, GPS, I'm sure there are wonderful pros and cons, but if we are not measuring a large portion of our system, and we can't monitor really in any meaningful way how we're doing, so that if we only measure our most severe cases, or what we perceive to be our most severe cases, I think what we may be missing is what truly may be our more severe cases, because kind of these rates of placement and reintroduction into care, and we haven't looked at homicide rates or child fatality rates or near fatality rates, and whether those children have been reported previously, et cetera, et cetera. I think a lot of that data lies in the GPS system. And we really have not had a way to look at that. And so I think that this data is probably highlighting that, and I'd just like your thoughts about that.
I would respond in a couple of ways. I think my sense is, and obviously Lori or Kathy could confirm this, I think counties have much of this information. I'm just not sure there has been a Commonwealth-wide effort to kind of put it together in a way that helps to drive decisions. I think having that information is absolutely critical for the kind of deliberations that you are undertaking, as well as I think the role that the state plays. The number of youth who are assessed under GPS is critical in understanding how the child protection system as a whole works, and I think having that information is critical, and at least on a national level, that information isn't available.
David, first off, I want to thank you so much for coming and for being here with us and sharing this information. And every time I hear you talk, I'm always fascinated about all the things you know and how we put it into context here for Pennsylvania. And when we talk about GPS, one of the things that we've talked about is it just seems like child welfare is responsible for so much. Is our definition of neglect consistent with other states? And I don't mean to put you on the spot, but is it consistent with the definition other states use for neglect?
Under GPS?
Under GPS. I guess they don't consider GPS. We do, but are we looking at the same things?
I'm not sure. I haven't looked at how other states define neglect. I think that's something that we can certainly do. I don't know.
I think some of the drivers we're seeing are drug and alcohol issues. As far as a bigger policy perspective, I think we need to look at, do we have enough resources? Are we treating drug and alcohol the way we should be? Another driver is, our adolescent population, and with parent-child conflict, as well as truancy behaviors. And I don't know how other states deal with that, but those seem to be areas where, as I meet with all the children youth administrators around the state, they're telling me that's where they're spending so much of their time, are on those kind of issues. And I'm just wondering, are other states doing that? Because I also saw that we spend a lot per child, more than other states do. So there's even more I think I'm going to be asking of you. I guess that's what I'm trying to tell you. Because, again, where are we spending our time? I see both sides of, we want to focus on safety issues. We want to focus on neglect issues that will lead to ongoing behaviors, problem behaviors within families and children, so we get them early. But I have no idea what we do with these adolescent behaviors, the drug and alcohol behaviors. You also mentioned the child's behaviors. Is that a reflection of our mental health system, or do we not have adequate resources to address that? Are those kids coming to our system versus the mental health system because we don't have the resources? So those are the kinds of things I still have questions about. The other thing with congregate care, definitely we know that we are utilizing congregate care more, and I just heard a presentation, actually the JCJC brought in some people that talked to us about how they're doing a study in Philadelphia, and what they're seeing is that congregate care just leads to another step of congregate care. So have we gotten ourselves in a situation where, especially with our adolescent population, we're removing children, putting them in congregate care because the word is there's no foster care for adolescents, then they move to another level, congregate care, and another level, and they remain in that system. And I just think those are, as we look at the holistic policy discussions around where's our dollars going, as we look at child welfare and child abuse and what our role is, we have to look at what else are we doing that maybe should be elsewhere, or I don't want to look at it in a vacuum. I guess that's what I'm saying. Our Pennsylvania Commission on Crime and Delinquency, the governor's office has asked them to look at some justice reinvestment issues, looking at because we have more people than many states in prison as well. So again, there's more going on here that I think we need to get our arms around. I think child welfare would like to focus on safety, well-being, permanency issues. We want to focus on what's real. We want to focus on those neglect issues that will lead to ongoing problems within children and families' lives. That's what we believe we should do. I'm just wondering if we're doing so much else that we're missing that piece. So, sorry I rambled a little bit, but I have a lot to say, and I can't.
Well, I think, let me take a stab at, because while we have your wonderful expertise here, the description that Ms. Macrath has just given is certainly consistent with my sort of understanding some of the features of Pennsylvania. Knowing what you know about what's being done around the country as a whole, are there, let's say, just upfront kind of, gee, if I were king of Pennsylvania, these are 3 or 4 or 5 things that I'd look at to change the approach, or from the macro to the micro?
I probably respond in several ways, because I think that it really is the unique features of each state and of jurisdictions that's so critical to consider in this work. And I think that Lori actually touched on it in the description of Montgomery County. They've been able to do some things that probably don't happen in other counties, and that's probably a good thing, that it's responsive to the local needs and making sure that that's maintained. And I think that's really the challenge in some ways with the CPS GPS. I think, at least from my view, the clear definition of CPS as the focus of the agency from the state perspective gives counties flexibility then to decide how they want to deal with things that fall outside of that. And I think it's a challenging balance to figure out how strong should the state oversight role be, how consistent should things be across counties versus how much flexibility is given to address county needs, saying that there's minimum standards identified in CPS, but beyond that, counties really have some flexibility. And I think that's one of the areas that I think is going to be really important to continue to consider, although I do think having the information about GPS is important, because I think that before moving into the role at Casey, I was responsible for child welfare in several large urban areas. And the distinction between neglect and abuse is often not that clear. And so not fully understanding what's happening in the GPS door, I think is important. So I think that's one of the areas, not necessarily changing it, but at least understanding what's happening and what the implications are, I think are really critical. I think a second area, and I think that Lori touched on it, and I've mentioned it several times, I would concur with entirely, is I think this overlap between law enforcement, the physicians, teachers, et cetera, I think really enhancing the kind of teaming that can occur in investigations is absolutely critical. And I think there are steps that have been taken. I think to the extent that can be strengthened and done on a statewide basis, I think that's really critical. I think that the issue of reporting and clarity about an employee of an institution and how they report abuse or neglect, I think is an important area to consider. I think that, as Kathy mentioned, things might be missed one way or the other, and I just think it's something to consider. So those are certainly areas. The one other thing I would just touch on, and I think it was the comments that Bev made earlier, and I think I heard Lori talk a little about this, that the resources generally are stretched, and making a decision to focus those resources on the most serious situations makes tremendous sense. I think that's the question about neglect. A lot of other states really struggle with where does the line from neglect cross into poverty, and are you effectively dealing with parental behavior? Are you dealing with somebody who's poor, who's not able to meet their child's needs, and how do you balance that? And I think that if Pennsylvania moves into kind of broadening the definition of neglect, you potentially run into that kind of situation. So I think that I don't have clear answers, but I think those are all areas that are important to consider.
If I may, just so that I get this in my head, because it's occurred to me in listening to a couple of the witnesses, I think I hear you saying that the difference in the separate definition and separate tracking of the two categories isn't necessarily hurting children in itself, but that the lack of the ability to correlate the GPS data, to have it accessible, and to look at it in a picture where you're also considering abuse does hurt our ability to identify abuse in some cases and to respond appropriately.
3,000 miles away, I would say that's what it appears. I think that it's a large number of youth that counties are serving, and not being able to look at how many of those come back into the system, for what reason, those kinds of pieces of information I think is important.
Well, and just one other, I'm sure you're generally aware, especially if you're spending $9 million here, we've heard what Mr. Carville's description of Pennsylvania. We know the enormous diversity, and as a next door neighbor to Montgomery County, they're even richer than we are, although they've got more people. And well, no, shaking your head. Talk to my commissioners, but that the diversity of resources, if you will, within a given county is certainly got to be one of the challenges, and I'm sort of racking my brain to figure out how we can, by creating templates, by doing things that don't necessarily mean that, the governor has to strike a new kind of energy that the state owns and fund everything anybody wants to do, but that we can create models for counties that, as a practical matter, just aren't going to be able to evolve the system that Montgomery County has, just for pure dollars and cents reasons. That maybe if we can't buy the personnel, but can we replicate programs? Can we educate? Can we figure ways? Do you have any thoughts about that?
Where it seems that has happened, and I would point to some of the work that's occurred in Minnesota, partly, and it's a state-supervised, county-administered state, but has moved aggressively towards more of a family assessment model of assessing complaints of abuse or neglect versus a purely investigatory kind of approach, and has shifted some things in the system. It's a statewide approach, but they have to attend to all of the counties in the state. And I think I don't have kind of this is exactly what it looks like, but I think some of the components that are important are the inclusion of leadership across multiple systems. And I think the court plays a critical role. And I think because they are responsible for most decisions in the dependency system, and so making sure that the court is part of the process and really looking at how things are, how there's consistency assured across states. I think the relationship between the state and counties is critical, because there needs to be enough flexibility for counties to carry out, as you said, in a very diverse state, carry out their responsibilities. At the same time, the state really should be defining some of the minimum standards and being clear that both are able to carry out their role, and they're working closely in doing that. I think that the one common theme that we see where that seems to have worked is really having data to drive the decisions. And is there concern about variations in performance across counties or not? And it's important to know if that's something that needs to be attended to or not. So there are some things that seem to be consistent components for those states that have struck that balance, particularly the state supervised county administered states, and being able to do that. But it's a challenge, and I don't have kind of a single answer, but I think those components, making sure the court is playing a strong leadership role, really defining kind of the minimum standards and using data to determine how successfully are counties meeting those standards, but assuring that that flexibility that counties need is built into this, and that relationship between the state and counties is critical. The legislature plays a key role in defining what the system should accomplish, and in some ways, if the legislature plays a role focused on outcomes versus process, that can be really helpful, defining exactly what the system should be accomplishing. So I think there are several things that are components that might help to contribute to that.
Thank you very much. You took my rambling soliloquy and actually brought a wonderful amount of order out of it. And one of the things I'm sure we're going to be hearing from either the court directly, Justice Baer has been a leader in this area and has already reached out to us. But you're absolutely right. The judges, and particularly some of the smaller counties, are making decisions that will drive what happens to kids. Thank you, Doctor. Did you have?
Just one last question. You talked about alternative response, kind of as a new approach for the lower risk cases, whether they're from physical abuse or neglect. Is there data on the success of an alternative response system?
Actually, there are several fairly thorough research studies looking at both Missouri and Minnesota early on, and some other states that have implemented more recently have also put evaluation in place as they've implemented their processes. So, yeah, there actually is quite a bit.
Good. So you can refer me or okay, that's wonderful. Thank you.
Actually, I've been speaking of the role of judges. Judge Grimm, do you have any questions, comments? We've lost him. Ooh, actually, the screen's going blank. All right.
I have a question.
Oh, yes, go on.
Okay. I heard you talk about the flexibility that's still needed at the county level, but then I heard you say we need to define some minimum standards, and I guess I'd just like to know, are there any other risks or concerns by that type of county flexibility that we should be aware of?
I think that it's a challenge whether they're state-administered states or county-administered states. It seems the variation across an entity is a challenge for all organizations. And so there is the flexibility that's needed to meet community needs. At the same time, there probably is concern about the variation that might result in huge differences in safety for children. And so it really is balancing that. And most organizations, whether state or county, experience flexibility even within the unit. So I think the challenge is setting up systems that assure as much consistency in those key areas, and particularly in how children are doing in safety, permanency, and well-being, and allowing for flexibility in approaching this. So it's a challenge, I think, that that all states have struggled with, how to assure that balance. And I would imagine even within counties, it's a challenge.
Mr. Chairman, thank you, Mr. Sanders. Those states that you referenced throughout your presentation, and maybe you can speak generally, in the prosecution of child abuse or child abuse-related crimes, it's my understanding that there are many states that the equivalent of our district attorney here in the Commonwealth is the one that's responsible for those roles. Here in Pennsylvania, we kind of have what I call a bifurcated system, where we have, if the definition fits and the prosecutor thinks it warrants criminal prosecution, the district attorney's office spearheads that effort. And we have the civil investigative function that we've been talking a lot about. And so when we're looking at your data, I want to make sure I understand what we're looking at in the successful outcomes of investigations. Can you tell us, I hope I'm making some sense to you, are those states ones where they have a similar system to Pennsylvania, or somewhat something different, if you know?
I actually don't know. I think it's I mean, it is, if I'm clear on the question you're asking, in some states, the legal representation for the agency is distinct from the district attorney role, for example, and the district attorney would be responsible for prosecution. There may be another set of attorneys in a completely different structure that supports the dependency function. And so in making some of these determinations, is that a factor that makes a difference? Is it
a factor? I'm just wondering, when we looked at the data, could it be possibly we're looking at data that's not consistent with the way we do things here in Pennsylvania?
So I'm guessing, and this is a guess, we can take a closer look at it, that there is a different structure in the states, and I think we can kind of take a closer look to see if that has any impact on any of the information.
Thank you.
That's a really good question. We haven't looked at it that way.
Thank
before.
you.
Thank you very much, Mr. Sanders. It was a wonderful presentation. You bring a fabulous depth of knowledge to have. You have ended up being sort of a wall that we're throwing our ideas at, and you're able to make order out of them. So thank you very much, and I know that we can't count on having you here in the Commonwealth, but we know how to find you, and I hope we can continue to throw the odd whatever at you and get responses.
Thank you.
Thank you. And the final presentation, we're only an hour late. That's not bad given the weight of material we've been dealing with. Is the Joint State Government Commission and the wonderful, neatly bound report which you have produced.
Thank you.
And I apologize. I'm not in a position to introduce you, so perhaps you'll introduce yourself.
Good afternoon. I'm Steve Rare. I'm the counsel with the Joint State Government Commission. I'd like to present Yvonne Hirsch, who is one of our staff attorneys, and Helen Hanshina, who's one of our research analysts. Helen provided some background research for us in preparation for the report that's in front of you. Yvonne actually took the lead role, so there might be a time when I defer a lot of the questions and the overview to her, but she did a great job trying to pull together the information from all the states. In front of you, you should have the a document entitled Child Protection Statutes. What we've done is tried to pull together a 50-state survey of what's taking place across the country in various subject areas dealing with child protection. It does provide a thumbnail sketch, so to the extent that we need to talk more about particular issues, we can certainly research them in more detail, and if there are other issues that do come to the forefront, we can certainly look at those as well. There is a summary on page 1 of the draft report, and I will sort of highlight some of the things that are in that executive summary and in the tables themselves. We have summarized the information into 6 tables. They deal with child abuse and neglect, perpetrators of abuse, mandatory reporters, reporting procedures and expungement, investigative findings and investigative proceedings, temporary and emergency custody, and dependency proceedings. So as we walk through this, if you have any questions, please let us know if we can provide any additional information or explain what some of these charts say. Regarding the issue of the definition of perpetrator, most states tend to focus on abuse and neglect of the child within the home, either with a family member, could be a parent, could be a guardian or a paramour of a parent, or it could involve a situation where a child is under the care, custody, and control of another person who is in a position of authority with respect to the child. This could be a caretaker, a custodian, or a provider of residential services. We did find that there were a number of states that make no distinction based on who causes the abuse. We tend to make that distinction under the definition of perpetrator. We did find a number of states that do not, and those include Alabama, Alaska, Colorado, Connecticut, Idaho, Massachusetts, Nebraska, Oregon, Texas, Wisconsin, Wyoming, and New Hampshire. So there's a big geographical diversity of the states that do not make that particular distinction. We thought that might be helpful to summarize that, particularly if we're thinking about revising the definition. If the task force wants us to pursue any more specific information on that, we can certainly do so. With respect to child abuse, most states define it as physical injury, sexual abuse, sexual exploitation, mental or emotional abuse, and neglect. There are a number of states that also mention abandonment, and we came across 35 that do that. There are a number of states that are neighboring Pennsylvania that pull in abandonment. Those are New Jersey, New York, Ohio, and West Virginia, and some of the bigger states that are comparable to us in size and population also do that as well, such as California and Florida, Illinois, and Texas. We did find a number of exceptions from the definition of child abuse throughout the country, and these include the exercise of religious belief. We found that in 36 states. Reasonable parental discipline, we found that in 17 states. Poverty, we found in 11 states. And again, everything is categorized in the tables themselves in the back of the report. The reports of suspected abuse may be made by anyone, and we found that clear across the country. But they are mandatory for certain professionals, as we have in Pennsylvania. In more than half the states, reports are to be made by identified professionals regardless of the circumstances in which they encounter or discover the suspected abuse. 18 states limit that responsibility to those situations where a reporter encounters such abuse in the course of employment or in his or her professional or official capacity. 11 states specify that all persons are mandatory reporters. Now, we've alluded to that throughout the morning testimony, but those 11 states are Idaho, Indiana, Kentucky, Nebraska, New Jersey, New Mexico, North Carolina, Oklahoma, Tennessee, Texas, and Wyoming. What we've done in the report is we've divided the mandatory reporters into 4 different categories. We thought that might be a nice way to break down the information. We've categorized them as healthcare professionals, mental health professionals, and social service providers. Third, as schools and daycare facilities. And fourth, as law enforcement officials and the members of the justice system. Interestingly, there are a number of other states that deal with other professionals as well, such as the clergy, which and again, there are some limits in terms of what can be disclosed, but the clergy, we found that came out in 21 states. Film processors, the people who develop film, came out in 7 states. Computer technicians in 4 states, and animal control, veterinarians, and humane society workers, we found that in 6 states, under the assumption that, as we were talking about that, it did seem sort of strange on first blush, but if there is abuse to an animal, there could be an extension to abuse to children as well. We found that 17 states address the situation where a staff member of an institution is a mandated reporter. Now, in the charts themselves, we do tend to break that down as well, but in 9 of those states, 9 of those 17, reporting the abuse to a superior absolves the staff person of any further liability to report. These states include Georgia, Idaho, Maine, Massachusetts, Missouri, New York, Vermont, Washington, and Maryland. In 8 of the 17 states, the law is such that when you do a report to a superior, that does not absolve the staff person of the individual responsibility to report. And those states are Alaska, California, Hawaii, Illinois, Indiana, Michigan, Wisconsin, and Kentucky. Sure, absolutely.
Just a little caveat on that.
Oh,
Sorry. Oh, thank you. While New York and Wisconsin absolve you of responsibility, they make a specific provision that says it's not intended to let you off the hook, basically, unless you're aware that another report has been made or is going to be made. So there's a little out for that. And then in Missouri and Maine, when you do the report, it also gives those people the ability to file a separate report on their own, even though they've gone through the institutional staff. So there are some little variations on that going on that address the concerns about whether or not there's any kind of follow-up once the report's been made.
And as you can imagine, there's not a black and white issue. There are all kinds of shades of gray in terms of what conditions are made, what exceptions are made. So it's sort of difficult to compare apples and oranges at times, but we'll do the best we can to get through it in that respect.
Well, you've done a wonderful job of summarizing. Let me just ask, I noticed for at least the one state, the prior New Jersey, that has universal duty, the penalty was very low. It appeared to be pretty much, I'm not that well versed with New Jersey law, but it sounds pretty much like a traffic ticket. Is that fairly consistent across some of the other states that
It's almost universally a misdemeanor, not a high-grade misdemeanor. In most states, there are a handful of states that if you do it repeatedly, then it can become a felony. There are 2 states where part of the penalty is if you fail to report, it's reported to your state licensing board. So if you were a doctor not reporting, it would go to the medical board. So but generally, it's a relatively low penalty for failure to report.
and particularly where, for professionals, it's a whole sort of different kettle of fish, but where any citizen is involved, I assume, are they cases that, for instance, would involve jury trials in those jurisdictions?
We actually haven't delved into that much detail. Again, we wanted to provide the thumbnail sketch, and then if there are issues like that, we can delve into it more in detail. It got so overwhelming to try to pick apart those individual distinctions.
And not all states criminalize it. There are states where it is just a fine. I think it may be about 2/3 of the state where there's actually a criminal penalty for failure to report. And in the other states, it may be a fine or something along those lines.
May I ask a question, Mr. Chairman? In any of those states, do those that are mandated reporters that are licensed by the state, does a failure to report impact their license?
Two states, and I'm not sure if I pulled it out in the summary or not.
They may not be listed there, but they're back in the tables. We can dig
I
that
actually have them in
information
my
out for
notes.
you.
I could get that for you. But
Sure.
and I'm trying to, I can't remember off the top of my head who they are now, but there were 2 states that specifically provided that it went to the licensing board.
I have a somewhat of a larger question. I'm not so sure you have the answer, and I don't know how you define, like, the answer. And, David, if you have any information, I'd be interested. But mandating that all adults in a state have to report suspected abuse, does it change the number of reports that come in? Does it improve the recognition of child abuse? Does it overwhelm the state? I mean, is there any data on what do you do when you mandate that everybody is a mandated reporter?
In terms of the specific data, we didn't delve into that, at least at this point. We tried to focus on the state statutes and the actual how the law actually worked on the surface. But certainly, if there are individual states that stand out to the task force that might say, well, these 2 conditions hold, so what's that effect on the system? We can certainly look at that in much more detail.
There may be, and we'd have to look more deeply into it, but there may be a state that went from a select number to everyone, in which case they may very well have some data, some statistics that would tell you that, but we'd have to go look at that. But I think that's where you would find it if there was actually a change, where there's some follow-up.
Thank you.
Well, you've given us the raw material, and we will try and focus. Don't just check all 50 states, because, but yeah, that's, the lawyers among us will get ourselves down to the law library, figure out what the provisions are. So long as you've given us the citations, that's, and a characterization of them, so we're way ahead. I'm sorry, I interrupted your presentation.
That's okay.
The floor is once again yours.
Were you done?
Actually, just had a few more quick things just to tie it up. Also, in chart number 4, where we do talk about some of the penalties, it does go into the expungement of records, so that's another issue that I know the task force had raised, at least briefly. So there is the start of that particular research. Table 5 deals with the investigative findings. In Pennsylvania, of course, we have our own set of terminology. There are, like, for example, 15 states that use substantiated, unsubstantiated. There are 5 states that use founded or unfounded. There are 2 states that use indicated, not indicated. States use a combination of these things. They add other terms. So it's sort of difficult to try to navigate through that particular thing. But also, the level of proof also varies from state to state. So if that's an issue that we should look into, we can certainly do that. It was alluded to previously about the who can file petitions, dependency proceedings, and whatnot. That's in Table 6. We sort of tried to summarize at least a little bit of that and explain the timing and disposition of reports, temporary and emergency custody measures, and things along those lines. We also, before I turn it over to Yvonne, we also wanted to acknowledge that we did receive an email from Dr. Berger. I think all of the members of the task force did. We had covered, unwittingly, a number of the issues that she had raised, but I know there were a couple of other things that were in her email that we can pursue after this task force meeting. And I think there were some other emails that came through that we can look at that information as well. So I would just say that, any additional information, please feel free to let us know what we can provide. In addition to even drafting legislation, we will be glad to do that and help the task force walk through the process. And let me turn it over to Yvonne. I know she has some things that she'd like to respond to based on what was talked about earlier today.
I thought I'd go page by page and kind of summarize it for you. No. I don't know about anybody else, but I'm getting hungry. There were just a couple of points I wanted to follow up on, things that were brought up during the other presentations that we've been looking at. Looking at the definition of abuse, especially physical abuse in Pennsylvania. We have a very subjective standard. We are in a distinct minority with that. And one of the follow-up things that we've initiated already is to go back to those states and look at exactly how they're defining those kinds of abuse. Because in some states, you have a laundry list, that there's hematomas, there's skull fractures, if it's that kind of result, then it's a reportable incident. So we're certainly, I would say, probably under a dozen states that use some subjective standards. Most objectify what they're looking for. So we're trying to pull that together to present to you moving forward. We talked about the mandatory reporters in the institutional setting. Mr. Koutourakis had asked a question about reporters getting information on outcomes of the reports. And there are states that specifically authorize the reporter to automatically receive information. Others have a process where when you make a mandated reporter, and it's not for all reporters, but for mandated reporters, that a mandated reporter can basically fill out a form and say, I want to know what happened at the end, and get that information. So we'll try to pull some more of that together for you as to how that's done, that you get that kind of follow-up. The other thing we had covered somewhat, I'd like to go back and look at it a little more carefully, is where the initial report goes to and who responds to it. There are a number of states where the report will come into CPS, they will make an evaluation and refer it to law enforcement. Law enforcement will make an evaluation, refer to CPS. In some states, it goes to both at the same time. So trying to pull out some information on where those reports are coming in and how the two aspects, child protection and law enforcement, relate to each other and communicate that information back and forth so that there's follow-up when there are criminal charges to be followed, or if the call goes into the police and the police don't think it's a criminal case but want to refer it to CPS. So those are some of the things that we've heard, that to the extent we've addressed them, and we did very, again, not completely clear on where the task force was going, and I was glad to hear you say it wasn't all focused on sex abuse, because I didn't focus on sex abuse, so that made me feel better. One of the things we did was look at the temporary and emergency custody and what kind of time frames you have, how quickly you get kids in and out, how you deal with that. So there's an extensive amount on that in these tables. So we, like Steve said, it's an overview, and it's 145 pages long, so you would think it would be comprehensive, but it can go deeper. And to the extent you want us to go deeper on any particular thing, that's what we do.
It's still a working, breathing document as far as we're concerned.
Certainly gives us something to chew on. Maybe it's just because lunch is, or the time for lunch is past and lunch is approaching. I'm thinking about this process more and more like a meal. We've had an appetizer. We've had an appetizer, and the material, this and a bunch of the other material that we've been have now provided with is a first course, but we have a whole lot more yet to be presented to us to process. So that, but we're off to a wonderful start. Anything further? Any questions, Mr. Koutourakis?
Yeah, Mr. Chairman, I asked this question of Mr. Sanders, I believe, and maybe others. In your research, have you or can you try to identify which states, who has the lead role in prosecuting or bringing child abuse to conclusion? Is it the prosecutor's office only? Is it, I call Pennsylvania a bifurcated process, where we have criminal statutes that are being prosecuted by the district attorney's office, and then the child abuse investigation, if appealed, is handled by the county child welfare solicitor. And so I call that a bifurcated process, and I clarify it for that purpose. But have you gotten to the point in your research where you're seeing those things, or is that something you could look at as you continue?
We've touched upon it in the one of the later tables where we talk about the investigative process, and also in the dependency proceedings as to who's bringing these cases. So from a statutory perspective, we can certainly go back and tell you most states, the local district attorney will bring the case, or most states, the attorney for usually the Department of Social Services, Human Services, whatever that particular state calls it, will bring the prosecutions or the dependency petitions. Data-wise, who's doing that in a significant amount? We don't have it now. The national, some of the national data that Mr. Sanders referenced does have very comprehensive data on a state-by-state basis on a number of topics, including unique victims, meaning people's first time in, repeat victims, characteristics of perpetrators, all kinds of information like that. And I suspect there's going to be some of that data available, and they have it both on a yearly basis that the Department of Health and Human Services through the Children's Bureau collects this data annually, and then they also have a longitudinal study. And it was actually just, the latest version was just presented in 2010, which covered the years 2004 through 2009, and had a lot of data on how states were addressing specific issues over time. So if, and I've just looked very superficially at those documents, but I think if we go back, I think there's a good likelihood we can pull some of that out of there for you. It's the best I can tell you now.
Could you just, for just a minute, expand a little bit on when you refer to the definition of physical abuse as being subjective? Mm-hmm. Is it the issues of things like defining it by severe pain, or are there other things that you were referring to? What specifically were you referring to in defining our definition as subjective? Thank you.
The severe pain is certainly the first thing that leapt out. But another thing that Pennsylvania says, and some other states have said too, is a significant impairment of function. And what's a significant impairment of function? What's the level of function you were looking at to start out? What's your standard that you're comparing it to? So those are the kind of, those were really the two that leapt out at me, was this significant impairment. And because it's one thing to, you're in a cast for 6 weeks, but beyond that, and especially when you get into the emotional abuse and the psychological abuse, and you have and that's got to be universal across all states, because you're dealing with emotional abuse, but you get some very subjective issues. But in the physical abuse, it at least seemed to me that the majority of states are looking at a measurable, quantifiable, objective standard, and that we are in a minority looking at it very subjectively.
Thank you.
Oh, yes, Helen. Helen had actually looked at the definition of abuse in more in-depth for us. So.
I'd like to add something about mental and emotional abuse specifically, because many states realize that this may be a subjective category. They're actually more careful sometimes in saying that a professional, like a psychologist or a psychiatrist, has to confirm that there have been significant changes. And they also specify that there are behavioral changes or noticeable behavioral changes. And maybe a certification by a professional would be also more helpful in healthcare in general, not only mental and physical. Or mental and emotional.
Lori spoke about the multidisciplinary team investigation piece that they're doing in Montgomery County, and David Sanders talked about how he thought that that was a really good vehicle to work on these cases. I'm just wondering how we're even doing in Pennsylvania with our investigation and prosecution of cases involving child victims as we look at child abuse. So I would assume that that information should be readily accessible, I would think, but I'm wondering how are we doing in PA? Are we investigating and prosecuting cases? I think we can tell you how many cases come from Childline to law enforcement, but what are they doing with them? And then how do we compare with other states? So if you could look at that, that would be wonderful. Thank you.
Certainly. I know also when you talk about the multiple disciplinary team, there are a number of states that use that approach. When they were talking about the differential treatment, there are probably a dozen or more states, and that's just a ballpark figure, that have the diversionary approach where you have an evaluation of the report and decide if it goes to an assessment or if it goes to an investigation, and the concept of prioritizing the kind of complaints and different criteria to prioritize them. So there are a number of states that are doing that as well.
And actually, we've asked Pennsylvania Partnerships for Children about a couple months ago to begin the process of looking into that, so maybe you can partner with them to get some of the information they have, because we are very interested in looking at what does a differential response look like, and is it appropriate for Pennsylvania?
Pennsylvania's gotten into so many diversionary courts now, and it seems to be such a trend with that you would think it would be something that you'd be interested here as well.
And that might also assist us to look at what kids we're putting in congregate care, which ones can we divert from congregate care because they're not being placed for safety issues. Thank you.
Just one last question, and if it's in this data, forgive me for not identifying it. Is in the data the length or duration of the child abuse investigation by state? In other words, in Pennsylvania, we have 30 days with an extended period of another 30 days, up to 60, to conclude a CPS investigation.
It was not something that I was specifically consciously addressing, but probably in about 75% of the state cases, it's there because it's part of the whole investigative procedure that you have to initiate your response within X number of hours or days, and you have to finish. So to the extent where it was readily available in the state statute that I was looking at, I included it, but I didn't make a conscious effort to make sure I checked it 50 times. So I can certainly go back and look at that, but there is some information about that. A lot of it varies greatly. There can be a turnaround 30 days to 60 days. In some places, depending on the severity of the complaint, the turnaround in investigations to be completed in 7 days. So and I talk with my hands, I'm sorry.
Thank you again. Thanks.
Sure.
I'm not usually accused of being a Pollyanna, but all of the presenters have really been exceptional, and that is unquestionably attributable to the excellent staff support that we are blessed with. We're now at the point at which we're going to conclude these proceedings and get some lunch and do some planning for the next events. I did want to mention, and I wasn't being rude, I'm trying to I don't know how to work these things anyway, but perhaps Vicki or somebody could point out, well, no, you anticipate me. We have a website, and I wanted to call people's attention to it and mention for what it's worth to the record that I think through the good offices of the Senate, we...
LDP, yes, there'll be a tax...
Okay, but just, okay, so we don't have like it's through legislative,
It'll be through the, if people go to the Public Senate website, there'll be a link for it, and they'll be able to go on there, hopefully by tomorrow.
great, great. So, that's, and I mention that specifically because we need to all get our heads together about, I think we've identified dates when most of this very busy task force is available. We coincide. We hope to schedule at least 2 hearings, likely in Philadelphia and Pittsburgh, but I'm loath to, to announce the dates until we all consult. But for those of you who are here and interested in these proceedings, certainly we'll put that up on the website and otherwise publicize those dates as soon as they are fixed. And unless anyone has anything else for the good of the order, thank you again, and we are concluded.